Well, hello everyone, and welcome to Uncivil Law. I hope you are very well as always. And we are here with another stream. My guest will be joining me in just a second. He's already on stream waiting to join you, and we are going to just talk about some law stuff. And then we're going to talk a little bit about a Supreme Court case, because it's one of the things I do on my channel is react to Supreme Court oral arguments. So we're going to react to a recent case on from the Supreme Court as part of my ongoing series of Scottish React. And we'll also talk about some other stuff. But to join me is Nick himself from his law channel, Recchietta Law. Hello, Nick.
Hey, what's up, man? Long time no see.
Yes, it's been only a day. And then before that, another day. And then tomorrow's Thanksgiving. We have the Thanksgiving special.
It'll be great. Yeah. Well, who's wearing the tux and who's doing the singing for the Thanksgiving special?
I don't know. I'm feeling like you can dress up as the turkey, man.
No, only in the minds of people who don't like me. No.
yeah, that's right. So I don't want to talk about the election too much because we've both been talking about it a little bit, and I'm a little tired. And I thought maybe we'd do some other stuff.
Yeah,
but, just to catch up with what's going on, there was that injunction that was put in place by a random Pennsylvania court. It's an injunction that's in place for 2 days for a hearing. Will it amount to anything in the end? I don't know. And also that the legislature in Senate is also hearing some testimony. Will that amount to anything? I don't know. But at the moment, I don't want to cover it live. And there's nothing really to talk about in the court case right now because it's a pause for 2 days before we have a hearing. So we won't panic. However, of note, of other legal news, Michael Flynn has been pardoned.
Yes, he has.
I was trying to find the exact copy of the pardon because I wanted to know what the scope of the pardon was. Was it for specific events or specific time periods, or is it what you might call a global pardon? Any and all federal crimes committed on or before these dates or something like that. So how was the pardon actually written? I was trying to find out and I couldn't find out. It wasn't available on Department of Justice's website. There's a couple of reasons that matters. First of all, there's this idea that acceptance of a pardon can constitute acceptance of guilt of the crime. But if it's a global pardon, then it's like acceptance of what crime? Because it's just any and all crimes. So there's not so much the implication there with that. The other reason that matters, if it's for anything specific or series of specific things, then he could still be liable for other things or whatever. But I'm imagining it's probably a global pardon, although I haven't seen it yet. And this is exactly what Judge Sullivan, I think, was hoping for. So he's probably been working on the background, his magnum opus, about how the dismissal of the Flynn case because of the pardon is a travesty of justice, a travesty of America, a thorn in the eye of all that is good and right and decent in this world, and how he has no choice but sadly to let this travesty go forward because the pardon has been successful. So I'm sure he's been working on this in the background, and he will shortly come out with his 30 to 50 opinion. Woe is justice. Woe is us all. God save the United States opinion. I look forward to covering that.
And you actually mentioned this on my stream. I think the first stream we did together, we were talking about Michael Flynn at the time, and you said that you believe this is the way Sullivan was going to go, was to either delay it out past the election for Trump to do the pardon, or to have him pardon, I guess, if see, this is what I find interesting about it, not to talk about election stuff, but it's an indication in some ways that maybe they're looking at a possibility that Trump won't be in for a second term. So they're starting to do some of the tidying up of these types of issues. Right. There's talks about pardoning Paul Manafort as well. Mm-hmm. And we can expect maybe a Steve Bannon pardon coming in addition to that over the wall scandal stuff, or the wall GoFundMe. I do want to say one very brief thing about the Pennsylvania suit and the Senate hearings, or the Pennsylvania legislature hearings, is I'm going to be covering those tonight on my channel. So if people want to come tune in for that, we'll go into a little bit more depth there. But the implications of the Pennsylvania lawsuit are really wild and big. That's what makes it such an interesting case, and similarly very difficult, because they've actually held elections two of them now under the rules that they're now saying are unconstitutional. And so there's a weirdo on Twitter screaming about latches, but constitutionality, latches doesn't really go into that on the overall principle. However, it may play into that for this election. So the implications are weird and very much up in the air, but definitely if you want to come talk about it, come talk tonight. For now, let's avoid election talk.
Let's do something else. Let's talk about there are other issues in the world beyond that. So as I mentioned, one of the things I like to do on my channel is listen to and react to Supreme Court oral arguments, because they're usually interesting. They're usually fighting novel issues, and we can listen to what are good arguments or what not are good arguments, what we do or do not find persuasive. So, as before, anytime you want to interrupt me, Nick, just let me know and I'll be happy to pause it.
Yeah. Well, and not to mention that oral arguments in front of the United States Supreme Court tend to be some of the best lawyers in the country. That they're the ones who get these types of cases, who drag them up. And even if a different lawyer represented at the lower court level, they'll bring in someone with Supreme Court level experience to deliver oral argument, because it's such a momentous and important occasion that they want to get it right.
Absolutely. So we are going to do this case, I think, today. This is Torres versus Madrid. That was argued in October 14th of this year. So it was argued last month. And we'll just give you a brief fact. This, by the way, is coming courtesy of Oye. In case you ever want to know how to pronounce that, it's pronounced Oye, O-Y-E-Z, Oye.
I still say Oye.
Because French. Anyways, so yeah, this is courtesy of Oye, and the reason we use them is because they have the transcript and they also have highlighting who exactly is talking, and so it's a little bit easier to track. So anyways, let's cover the facts of the case. In 2014, Roxanne Torres was involved in an incident with police officers in which she was operating a vehicle under the influence of methamphetamine, and in the process of trying to get away, endangered the two police officers pursuing her. In the process, one of the officers shot and injured her. Torres pled no contest to 3 crimes: aggravated fleeing from a law enforcement officer, assault on a police officer, and unlawfully taking a motor vehicle. So she pled no contest, which is just guilt without the underlying admission of the act, and so she accepted criminal liability. Then in 2016, she filed a civil rights complaint in federal court against the 2 officers, alleging claims including excessive force and conspiracy to engage in excessive force. So she says the amount of force used against me was improper. Construing Torres's claim as asserting the excessive force claims under the 4th Amendment, the court concluded the officers were entitled to qualified immunity, which is a doctrine we've covered many times on this channel, and that we have serious pause with at best.
Really the best. It's terrific.
Yeah. In the court's view, the officers, now this is the critical part for today. This is the riddle. So it wasn't even the clearly established part. So for qualified immunity, you need 2 things. You need to be a constitutional violation, and it needs to be a clearly established constitutional violation. So actually the court failed this on step 1. They said there wasn't a constitutional violation. So in the court's view, the courts had not seized Torres at the time of the shooting. And without the seizure, there could be no 4th Amendment violation. So it wasn't that her right was not clearly established. They're saying there wasn't a right at all. They did not seize her because she got away. That's what they said. The United States Court of Appeals for the 10th Circuit affirmed, thus, the question to be decided by the court: must physical force used to detain a suspect be successful to constitute a seizure under the 4th Amendment? Now, what is really interesting on this is that there is a split. There's a circuit split on this issue. Some circuits say yes, and some circuits say no. And for those of you who know things about the Supreme Court, you know that's one of the reasons that they decide to take cases or not is based on these circuit splits. So when there's a division of authority, that's one of the reasons the Supreme Court gets involved to reaffirm or to decide what the law is on this thing. Let me see if I can just find out real quickly which circuits are splitting what's there. Okay, so here's the circuit split that exists. The 8th, 9th, and 11th the 8th, 9th, and 11th circuits and the New Mexico Supreme Court have held that that the unsuccessful attempt does count, and the 10th Circuit and the District Court of Columbia, or of District Court of Appeals in District of Columbia, have held not. So the 10th Circuit and District Court of Columbia Court of Appeals are on one side of the issue, and the 8th, 9th, and 11th Circuits are on the other side of the issue as to whether or not shooting at someone constitutes a seizure. In my humble opinion, the answer to this question is yes.
Yeah, it seems weird to think that a police officer firing a weapon and hitting them, right? They were struck by the weapon.
There was an injury. I don't know if it was from the weapon, but it wasn't specified, but I think so.
It seems weird that would not be a seizure under Fourth Amendment considerations. However, looking up on the Cornell Law Legal Information Institute on Cornell, they have listed the two elements for a seizure. And it says, first, there must be a show of authority by the police officer. Presence of handcuffs or weapons, the use of forceful language and physical contact are strong indicators of authority. Second, the person being seized must submit to the authority. An individual, now they don't have a citation for this, but an individual who ignores the officer's request and walks away has not been seized for Fourth Amendment purposes. So I guess they have the two elements as one of them not being, the second one not being fulfilled because the plaintiff or the appellant here is allegedly did not submit to the authority of the police officer. So I guess they're saying you don't have a seizure. Although, I mean, I don't know. It seems like at some point there is a seizure that happens. So it's kind of weird, but yeah, very interesting.
Yeah, well, the law can often be very weird. So we are going to listen to this oral argument and see what the justices have to say on this issue.
I'm going to pull up the case and see what the facts underlying have. Oh, there's the facts right here as part of the oral argument. I guess we'll just listen to them then.
Yeah, absolutely. Now, because I know someone will ask, because people have asked me before, Amy Coney Barrett is not pictured here because apparently her official photograph has not been taken. So she would be on this picture to the right of Gorsuch. And in case you're interested in terms of how they choose seating order, it's based on seniority. So they alternate from left to right based on seniority. So Chief Justice Roberts is the most senior, and then to his right, or pictured on the left here, is Thomas, because he's the longest serving, and then it alternates back and forth. So in this, she would be furthest left as sitting on the bench, or furthest right from our perspective, but she doesn't have a picture because no one's bothered to take it yet. So let's listen in and see what they have to say.
We will hear argument first this morning in case 19-292, Torres versus Madrid. Ms. Corcoran.
Mr. Chief Justice, and may it please the court, in the early morning, respondents approached Roxanne Torres in her car and attempted to open the door without announcing they were police officers. Believing she was being carjacked, Ms. Torres drove away, and as she did, respondents fired 13 shots at her. 2 of the bullets hit her in the back. In rejecting Ms. Torres' claim that the shooting violated the Fourth Amendment, the Court of Appeals did not consider whether respondents' use of deadly force was reasonable. By the court's reasoning, respondents could have shot Ms. Torres without any provocation, and it would not have violated the Fourth Amendment because instead of remaining in the parking lot, she drove herself to the hospital. The Court of Appeals' decision conflicts with the ordinary meaning of the word seizure at the time of the Fourth Amendment's adoption, and it conflicts with this court's precedent. In Hadari D., the court unanimously recognized that when a government officer inflicts physical force on a person with the intent to restrain them, that person is seized within the meaning of the Fourth Amendment, regardless of whether that restraint is successful. As Hadari D. explains, this is because the Fourth Amendment must protect today what it protected when it was adopted. And in determining what the Fourth Amendment protected at the founding, this court has always looked to the common law definitions of search and seizure, and with respect to seizures of persons, the common law of arrest. The court explained in Atwater that an examination of the common law of arrest tells us what the founding generation would have understood to be an unreasonable seizure of a person. The common law of arrest leaves no doubt that when respondents' bullets entered Ms. Torres' back, she was seized within the original meaning of the Fourth Amendment. Several centuries worth of cases and commentary, both before and after the founding, uniformly recognized that physical force intended to restrain is an arrest, even if the subject evades capture.
All right, can we pause real quick?
Sure.
All right, so Fourth Amendment seizure, the simplified version of it is, would a reasonable person situated in this fact scenario feel free to leave? That's the question. So if there's a cop trying to handcuff you, you're probably not free to leave. If there's a cop commanding you to stop, you're not free to leave. If they say freeze or sit down over there, if they've given you an order, you're not free to leave. A handy test of this, not recommended all the time, but would be to try to walk calmly away or to say no thank you. But a police officer asking for your identification is not necessarily a seizure. If you ask for your identification, you say no thanks and try to leave, and he says nope, halt, halt, right? Like in Daggerfall or something. That is now a seizure for the purposes of the Fourth Amendment. So the question that one would presumably ask in this situation is, if the police have shot you for leaving, are you free to go? That's sort of the common sense approach to this.
Yeah, and my understanding of the case law in general would say that that the use of that shooting someone constitutes a seizure, because if the person died or something, you'd be thinking about it as a seizure and excess force. Right. Even like Tennessee versus Garner, where the police shot at Garner as he was fleeing in order to prevent him from fleeing, and that was held to be unconstitutional. So normally you'd think of shooting someone, or especially if you hit them. Now, you might have an interesting idea if they missed, I guess, but the idea that actually hitting them does not a seizure make is slightly weird. But apparently it's slightly weird that the 10th Circuit and the DC Court of Appeals think makes sense. So, okay.
I'd be curious about the underlying case, the facts of those cases where they found it. Because there's always this idea that, sure, that in some circumstances, like maybe you said, maybe a police officer fired a warning shot into the air, which is unlikely. They're not trained to do that. But if they did, or some other use of force where the force was not successful, the forceful contact was missed, like they try to grab someone and the person gets away. Clearly they're trying to restrain them and the person doesn't. That's different than a bullet entering your body. So it could be something like that. I'm curious about what it is.
Yeah. And also, just by way of aside, just a couple other little technical notes. Starting last year, the Supreme Court changed the rules to give the first 2 minutes without interruption. So under the rules, they used to have, they could interrupt you at any time, but they changed the rules year before last to give you the first 2 minutes for free. And so as a result of that, you get these wonderful 2-minute little monologues you didn't used to get, where it just wonderfully lays out the case and just lays out the fact pattern. So I thought it was a really good change. The other one that is of note is the audio is not as good as it might be because they're participating via telephone. They're not meeting in person. So, the audio is not as good as it would be. And also, as a result of that, they've moved to a different questioning format. So when they do this live, any justice can ask any question at any time and they interrupt each other. Now they've decided apparently that's a bad plan. So they go by order of seniority. They get some amount of time that's fixed because they each get equal time. They just go in order of seniority and they don't interrupt each other. It also has a side benefit that we get to hear Justice Thomas ask questions, which is bizarro world because he doesn't ask questions. Ever. But he does now because he has 2 minutes. I guess I'm going to use them. Okay.
Ms. Corcoran, what if the police had shot out the tires of her car, but she was able to continue driving on? There were those self-sealing tires that you can get. Would that be a seizure?
No, it would not, because there would be no application of physical force to her body.
Well, I thought there was an element of intent to hamper movement to your analysis. So what if they were aiming at the wheels or tires, but hit her while aiming somewhere else?
So
would that be a seizure?
Yes, so they have shot her tires, and but they've shot at her tires, but unintentionally hit her.
Yes.
Yes, understood. So under those circumstances, the answer would be yes, because they have physically impacted her through means intentionally applied. That's the test from Brower.
But they're applied to the car, really, not to her. It was only inadvertent that they struck her. I thought there was a requirement of hampering movement or laying of hands, for that matter, and you wouldn't have that, or would you? Are you saying if it's completely inadvertent, it still constitutes a seizure?
No, because in that circumstance, they are shooting at the car with the intent to restrain the driver. I think that would be akin to the barricade erected in Brower, which this court held seized the driver there because he was seized by the instrumentality put in place or set in motion by the police in order to affect the seizure.
Thank you, counsel. Justice Thomas?
Hi, thank you, Chief Justice. Yes, Ms. Cochran, are there any cases at common law where the touching there was a distinction between touching with an inanimate object or a projectile as opposed to actual corporal touching or laying on of hands, as the Chief Justice mentioned?
Yes, so there was one case from 1604, the Countess of Rutland, where the Sergeant of Arms effectuated the seizure by touching the Countess with the edge of the mace and declaring her his prisoner. But more generally, because during the founding era,
you gotta love it. You gotta love it for very possible reasons. Like, is there any case of common law? Yes. Let me direct your attention back to 1604, when the Sergeant at Arms tried to arrest the Countess.
Apprehension by literal mace, not by spray.
No, not by the spray. Not by the spray. The literal physical object, the literal physical base. Yes. This is 1604. Good times.
Now, interestingly, in modern or current jurisprudence, a projectile or inanimate object sent with the same intent of physical touch that you would have in reaching out and touching someone becomes an extension of the person. So in cases like battery, a bullet fired from your gun would be an extension of your arm, so to speak, under the legal principles. So they're trying to find out if there is a differentiation. I guess they're going to have to go back really far as well, clearly 1604. But yeah, it's hard to argue that throwing a rock at someone wasn't you doing it or firing a bullet, as it were. So. Also,
she seemed a little bit muddled in her answer, at least to my mind, with the bullet shot at the tire and whether it does or does not comprise a seizure. The question seemed to be asked because the idea of intent following the bullet. So if shooting at the tire does not a seizure make, and I was trying to shoot at the tire, that's my intent, but I actually hit her, then presumably that is also not intention, does not a seizure make, one would think. But her answer seemed inconsistent with that. And then she gave an answer dealing with this barricade, which is also stopping the car, but isn't in fact impacting the person. And she said, well, the barricade would constitute a seizure because of prior case. So her answers seem to muddle. It's like, does a bullet count or not? If we're trying to, even if we're trying to shoot the tire and succeed, isn't that the same thing as the barricade? And how not? Her answer seemed muddled.
Yeah, it seemed to, I mean, the intent of shooting a tire is to effectuate a stop on the vehicle and therefore the person driving the vehicle. So to me, that sort of transferred intent would, to use that doctrine, I guess, would not properly, but the sort of transfer of intent would go from the vehicle to the person, and therefore it would still be a seizure. So I'm not.
Yeah, sure. The car is kind of an extension of yourself. Same idea. You know, it's so closely associated with you that to seize the car is to seize you.
Right.
So yeah. All right. Fair enough. Let's learn some more about 1604 and the Countess.
The arrests were primarily effectuated by civil citizens who were not armed. it was far rarer for them to have any sort of a weapon or mechanism for applying physical force in that way.
Were those actual criminal prosecutions?
So the Countess of Rutland case was a civil case.
Ooh.
Most of the cases we cite are civil arrest cases because criminal arrests were rare at the founding. There was no police force in the United States until the 1840s, and criminal opinions were even rarer. We do cite one, State v. Townsend, and there are a few others from the antebellum era. But most of the cases from the founding era are civil arrest cases. As this court recognized in Payton, whether an arrest occurred at common law typically arose in the context of civil damages suits for false arrest or trespass on the body, similar to what we have here.
If someone is hit with a projectile and does,
I like that idea of trespass on the body, because that's alluding to an idea that's going to potentially appeal to Justice Scalia had the same idea with the putting this GPS device on the car exactly. So putting it as a physical trespass. So the Fourth Amendment violation is trespass to the person. That's a concept that's a little bit antiquated now, but from common law, you talk about trespass to the person. So if I hit someone else, I'm trespassing upon their physical person. So so you can look at it from a property right perspective. Essentially, if a property right in my body, you have trespassed improperly on that, and so they could put this not in a reasonable expectation framework, which is where the normal Fourth Amendment analysis goes. That reasonable expectation, or societal conventions, they could actually look at it from a property perspective. I like that answer very much.
And if she has picked up on what Clarence Thomas has just said, she should be pursuing that pretty heavily because of the originalist nature of Thomas Alito, appealing to that sort of originalism approach, which is why U.S. v. Jones is actually such a surprising decision in some ways, because Scalia was able to
Carpenter as well.
Scalia was able to short circuit the entire Fourth Amendment analysis and just say, well, of course it's Fourth Amendment violation. They trespassed upon his property. It's like, oh, well, thanks. But that's a good way to get a win. Yeah,
I like it very much. See if she develops that more.
Not stop. Let's say a rock, a snowball, a stone. Would that be an arrest or a seizure? Under your analysis or your approach?
Yes, I think under the standard that the court articulated in Brower, it would be, because the seizure is affected by the instrumentality put in place or set in motion to affect the seizure. That would be akin to the barricade in Brower.
Thank you.
Those Alaskan cops throwing snowballs.
Maybe this is just repetitious. Thank you. Good morning. But would you repeat or would you state your view on attempted seizures? It says the right for people to be secure against unreasonable seizures and searches shall not be violated. Well, does that include any right to be free of attempted seizures that are unreasonable?
No, because the founders didn't incorporate the common law of attempted seizures into the Constitution. So it's only the terms that the founders used in the Fourth Amendment that are incorporated into it and must be applied according to their original meaning.
Thank you. That's fine.
No,
I'm thrilled Justice Breyer actually asked a question in record time. That was nice.
Yeah, but did that answer was a little weird to me. So she's saying that the Constitution doesn't contemplate attempted seizures because it only contemplates seizures. Therefore, attempted seizures are seizures. Is that what she's saying?
Well, she seems to be. The question was, did they incorporate attempted seizures? And the answer is no. And so we all know where Justice Breyer's opinion is going, right? Justice Breyer is going to say this is not a seizure within the meaning of the Fourth Amendment. He's going to try to choke the conservatives on originalism, which should be hilarious. So he's going to try to write this originalist opinion about how true originalism would say this is not, that you can't get the liability. So it's like, well, I know where one vote's going. That was fun.
That's a weird one. You'd think Breyer would be on the side of the person that the police were shooting at.
Yeah, you would think, but apparently not. And and Justice Breyer asked the most rambling questions of anyone I've ever listened to in my life.
He's yeah.
You know, I even agree with Justice Sotomayor or Justice Kagan. Occasionally they're questioning, and Justice Breyer drives me usually crazy. So for him not to drive me crazy was a nice change.
Good job, Stephen.
Toledo?
If a military sniper shoots someone from a distance of 1,000 yards, would we say that the sniper had seized that person?
Yes, because the sniper shot the bullet with the intent of applying physical force to the person in order to restrain them.
In ordinary speech, would we say that the sniper seized that person?
I think I agree with Hadari D's point that yes, ordinary meaning today.
It's a simple question. In ordinary speech, would we say that? We would say the sniper seized the person. I'll give you another example. If a baseball pitcher intentionally beams the batter, would we say, wow, that pitcher just seized the batter?
That's different.
I don't know that we would use it in that context, but I would point to Hadari D's example. She seized the purse snatcher, but he broke out of her grip.
Yeah, the person seized the purse snatcher because the person had a grip on the purse snatcher for at least a moment. So it's really hard for me to see how your argument squares with the language of the Fourth Amendment, which prohibits unreasonable seizures.
Ooh.
But let me move on very quickly to another point. Do you have any cases that hold that at common law, shooting someone constituted an arrest?
No, there were no shooting cases at the founding because arrests were not effectuated with guns at that point. But the court recognized
your argument is not consistent with the language of the Fourth Amendment, and you want us to expand the concept of an arrest beyond where it stood at common law. Is that correct?
No, Your Honor. We are asking the court to affirm the original meaning of the Fourth Amendment. I think that's important because we started by talking about what the word means today. But of course, for the purposes of interpreting constitutional text, we look to the ordinary meaning to the founding generation.
I thought your argument was that an arrest at common law constitutes a seizure. But you have no authority for the proposition that shooting somebody was an arrest at common law.
The court recognized in Castleman that the common law concept of force includes its indirect application to the extent that pulling a trigger would be considered an indirect application. But we look to the common law to determine what force was at the time. And I don't think there's any real dispute that shooting someone or hitting them with a bat or any sort of application of force using an instrument would have qualified under that original meaning of seizure.
Thank you.
Justice Sotomayor?
That was interesting.
Counsel, picking up on that last point, it is a little odd to say that a police officer who touches you has seized you in the common law, but if he has a baton in his hand and touches you with the baton, he's done so indirectly, so he hasn't seized you. And if he takes a gun and shoots the bullet at you, that's not a seizure because it's a projectile. I'm assuming what your statement was to my two prior colleagues is that the common law didn't draw that kind of distinction because it made no sense, correct?
That's
Safety
correct.
net Sotomayor.
You gotta love this. It's like, let me save you a little bit here. So they're giving you, it's like the reason that this never came up is because it doesn't make any sense. And it kind of doesn't make sense because it's like only by the police. But I thought, where we started off was normally when we think about the seizure, it's when you're not free to leave, or a reasonable person wouldn't feel free to leave. And there's a demonstration of force and all the rest of it. So strictly speaking, I don't think the police need to touch you or use any force on you of any description for you to be under seizure, to be under arrest, right? If the police are projecting enough force and they're telling you to stop and all the rest of it, like they tell you to stop and they say, if I don't, I'm going to shoot you. It's like, you probably don't feel free to leave. So you're probably under arrest before they ever lay a finger on you. So the idea that that they actually shoot you, it's still not arrest because you ran away. It's weird.
If you think about it this way, if you're in a chair,
and
you need to go to the bathroom, and you stand up to go to the bathroom, and a police officer or anyone else pulls a gun at you and points it at your head, they don't have to say anything. You probably sit back down. Like that's just how it goes, because the very obvious nonverbal cue is what you're doing is against the rule that they have established, and that's the assertion of authority. And I don't see any reason for vocalization of the seizing. It is. I get what Alito's doing. He's making a textualist argument that I guess in common usage, we don't think of seizing something as anything other than literally grasping it in our hands. But we haven't applied a common usage of seizure to Fourth Amendment law in forever, as far as I can tell.
I mean, a seizure by its own terms implies one of two things: either you're stopping something or you're taking something. So if you're seizing a part, the part can't move. If you're seizing by appropriating it, so it becomes yours, that's seizing, and that's consistent with the Fourth Amendment. So it'll be a little bit weird to use that in common speech because we use other terms for it. But it's like if I'm preventing you from doing something, moving, or if I'm taking something from yours, that would be seizure. And the idea that a police officer, what this seems to imply is a police officer could point a gun at you and shoot you and hit you and then say, "Oh, I'm sorry, never mind," and it wouldn't be a seizure. It's
You're
like,
free
you have taken something from me. you have trespassed upon my person, and also he seized my health and potential viability. So I don't think saying, "Oh, you're free to go now," means a seizure did not happen. These arguments are a little bit weird.
I think the interesting sniper analogy that, and you could maybe go back to Alito with is, well, what if a police officer during some sort of thing where you are a suspect were to fire rounds near you to prevent you from going to a certain place or to make you maintain your covered position? They would fire a round into a wall next to you or something like that for the purpose of suppressing your movement, a suppressing fire sort of thing. I mean, that would be pretty clearly a seizure with the intent to stop you from moving for whatever purpose that they had.
Yeah,
so it's
But Breyer and Alito seem like they're on one page of the here, and Sotomayor is over here to save them with like, those questions didn't even really make sense now, did they? Like, nope, not really. But I had to play along because I can't say your question doesn't make sense to the U.S. Supreme Court.
Have you taken your meds today?
No, you're not allowed to say that either. No.
Every circumstance you just described would have fallen within the original meaning of seizure at the founding.
Now, could you explain why this case is so important? Meaning, if you weren't to have a Fourth Amendment violation, would the Due Process Clause provide you with a remedy?
So I don't think that the remedy provided by the Due Process Clause is adequate here, at least under the current regime where we have the conscience shocking standard. There are all sorts of abuses by the government of power that would fall short of the conscience shocking standard, even though they would be unreasonable uses of excessive force.
Ooh,
thank you, counsel. Justice Kagan?
Ms. Corcoran, there are quite a number of statements in Hodari D that support your position, but Mr. Standridge says that they're all dicta and that we are not bound to take account of them. I was just wondering what your response to that was.
Certainly, the court's holding in Hodari D that the common law of arrest defines a Fourth Amendment seizure is binding precedent. That was the foundation of the court's finding of no seizure in that case. And the court's discussion of what the common law of arrest held, which was that touch intended to restrain is a seizure regardless of whether there's submission. I don't know that I would say it's binding in the sense that it was necessary to the court's outcome, but the court thoroughly considered the question presented here. Those were not generalized stray statements made in a different context. The court was considering this question, and all 9 justices agreed that the circumstances we have here would amount to a common law arrest and thus a Fourth Amendment seizure.
And as you read the common law cases, do you get any sense of why it was that those cases said that mere touch was enough? I mean, is there a rationale that accompanies that rule?
The founding generation recognized that the infliction of physical force on the body is itself an intrusion, regardless of whether the person is able to walk away. And this court recognized in an 1891 case, Union Pacific v. Botsford, that the touch of a stranger without lawful authority is itself an indignity, a trespass, and assault. And so that was the concept at the founding that the framers gave constitutional weight in the Fourth Amendment.
Well, thank you, Ms. Corcoran.
Yeah, good on her. Coming back to this trespass on the person thing,
right?
You've trespassed against the person. She's coming back to that idea. She's running right into to those cases that we were discussing earlier, and yeah, so she should be able to win the day.
Yeah, because and again, this is. I'm going to go back to the 2016 election. This was an issue with Corey Lewandowski touching a journalist by grabbing her wrist, and they made a big hubbub about it. But at the end of the day, even though he was not actually charged, and this is why Ben Shapiro left whatever publication he left, or I can't remember what it was. It doesn't matter.
Breitbart.
Oh, yeah, he left Breitbart because they refused to stand up for the journalist. Corey Lewandowski did commit a simple battery. He unwantedly touched someone. We don't always prosecute that, because if you prosecuted every unwanted touch, like you just touched someone on the shoulder at the mall, like to say, excuse me, that's technically a battery. But it is still technically a battery because at the founding and at common law, going back to what you're saying here, this intrusion upon your body that is unwanted is in and of itself a violation of your rights. The other person's right ends the moment they touch you without your consent. So, well,
I'd push back slightly, because there was the idea of what societal norms are in terms of what people would perceive. So, if I'm touching, this is going back to my discussion at Legal with the whole Captain Marvel thing. It's like, if I'm touching you on your shoulder for the purpose of getting your attention, then that is not something that society at large is prepared to recognize as a violation of your autonomy, because we live in a society. Versus me shooting you definitely is a violation of your autonomy. So, not every injury does the trespass necessarily make, but I think we're there under this one.
Right.
Yeah.
Brian and Taryn, if you want to be touched, that's all you.
Yeah, if you want to be touched, that's all you, man. It's not trespass with consent. It might be something else, though.
Justice Gorsuch?
Counsel, as I understand it, your client would have had a good common law claim in New Mexico, but for the statute of limitations running. Is that right?
There was no. I'm not. That's my understanding as well. I can confirm.
Okay, thank you. Thank you. That's fine. With respect to Hodari D, do you agree that the language you're relying on was not necessary to the decision?
The second part, that the common law of arrest does not require submission, was not necessary to the conclusion. However, the first part, which is that the common law of arrest defines a Fourth Amendment seizure, was necessary and therefore is binding.
Well, let's explore that. The common law of arrest, the laying on of hands, near as I can tell, it kind of arose in the Dickensian debt collector process. That if you could get a hand on somebody through the window of the house, that then enabled you to go in and grab them inside the house. What's incorrect about that, and why should we, in defining the word seizure, rely on debt collection practices and defining the term arrest in England?
So, as the court observed in Payton, at common law, disputes over whether arrest occurred typically arose in civil damages actions for trespass or false arrest. And that supports our position.
But they were usually in debt collection processes, isn't that correct?
There were, yes, a number of them are debt collector
Okay, and back then, guns were not unknown at that time, and it's pretty hard to find a case in which somebody's shot, and that's been held to be even an arrest, let alone a seizure. Isn't that right?
Yeah, yes, Your Honor, that's correct, because most arrests were effectuated by private citizens.
Okay, and then going back to the Chief Justice's example, if a huge roadblock were put before an individual and everybody shoots at him, but nobody hits him, but his window's open and he gets scraped going by. I mean, they meant to stop him with the roadblock and he gets scraped, so it's intentionally applied. That's a seizure under your theory, right?
I think so, if I followed the hypothetical correctly, in the sense that the shooting was intended, the bullet was intended to hit him.
Well, the bullet didn't hit him. There were bazookas going off. There's all sorts of massive show of force.
Man,
but he doesn't stop. He keeps going. He's blasting through at 100 miles an hour, and he blasts through, and on he goes. Bazookas firing everywhere. Still not seized by any of that because that's just show of force, but he gets scraped through the window as he goes by the roadblock, and that was intentionally applied force for sure. That's a seizure in your book, even though it wouldn't be seizure for show of force purposes, right?
So no, I don't think that scenario would. I understand now. Apologies, I misunderstood initially. There, the scraping, I think, is not caused by the means intentionally applied to restrain.
Well, let's say it is. Let's say it is intentionally applied force because they have a roadblock and they want the roadblock to stop him, and it scrapes him.
So yes, under this court's articulation of the intent requirement in Brower, but I just want to emphasize that the intent requirement.
So just to be clear, that is not a show of force seizure under Hodari D and its holding, but it is under your theory.
No, our theory is the exact same as Hodari D.
Thank you, counsel. Justice Kavanaugh.
Thank you, and good morning, Ms. Corcoran.
It was weird.
With respect to Brower, the other side, as you know, relies heavily on the language in that which says that a Fourth Amendment seizure occurs only when there is a governmental termination of freedom of movement through means intentionally applied. What would you suggest we do with that language?
So I would turn to what the court said in Armour and Company v. Wantock, which is that the words of our opinion must be read in light of the facts under discussion. And the entire focus of Brower, and in particular that sentence, is on the intent requirement. Did the officers who erected the barricade intend to restrain the driver for the purposes of a seizure? The driver there was killed on impact, so the termination of movement was besides the point in that case.
And then I think a few of the questions so far have tried to illustrate a potential distinction between how we normally use the word seizure in ordinary speech and how it's been used historically versus maybe the legal common law use that you've described. Is that accurate? How should we deal with that distinction between ordinary usage, and why shouldn't we just follow the ordinary usage of the term seizure?
I would look to Hodari D's discussion of this, which explains that to the extent the ordinary meaning of seizure at the time of the founding was more expansive than how we normally think about seizures today, it's the ordinary meaning at the time of the founding that controls, especially if the modern understanding risks diminishing the constitutional right. This court has repeatedly recognized that the Constitution must, at minimum, protect today what it protected at the time it was adopted.
Thank you.
They would do that in the Second Amendment cases.
Ms. Tableson? I'm sorry. Ms. Corcoran, you can take a minute to wrap up if you'd like.
Oh, thank you, Your Honor. I've said a lot today about the importance of preserving the Fourth Amendment's original protections, but our position also makes sense doctrinally and practically. This court has long recognized that at its core, the Fourth Amendment protects against unreasonable government intrusion with personal security, including invasive physical touch. We see that in Terry v. Ohio, Maryland v. King, and Winston v. Lee, among others. It's a principle that flows from the Fourth Amendment's express protection of the person, that is the body, and it's violated the moment a police officer applies physical force to a person's body, regardless of whether they're able to walk away.
Thank you, counsel. Ms. Tableson.
All right, so before we move on to the next speaker, I think we just can summarize what we think. So far, I thought it was a really good argument. I thought she did a very good job, very solid. She was very responsive to the arguments. She came forward with a very solid case, a little bit muddled perhaps in some parts, but then again, she's dealing with hypotheticals and trying to figure out what they're talking about, so that might be part of the problem. But I thought her overall analysis made sense. This is a seizure, and the questions that are trying to distinguish this don't really make sense. So what did you think so far?
I'm on Team Gorsuch in that I want bazookas and all of the bullets flying from behind a barricade that they're apparently able to bust through at 100 miles an hour and just keep on driving into the sunset. But they did get scraped, though.
Apparently, if the police set up a minefield that you're driving through and bring up some howitzers and maybe a nuke or something, but you only get a little bit, you only get a little singed or something. It doesn't really count. I don't know.
You also have to have someone standing outside the T-tops of your Trans Am playing a guitar while you drive through. No, that was such a weird, that was a weird hypothetical to go with there. But I think she explained it very well. What I'm surprised with is she didn't just go back to Brower and say, yeah, the intent of the barricade is to have him stop, and therefore that's everyone would readily understand it as such. Everyone would not feel perceived to leave. A reasonable person would not feel free to leave. Now, whether or not a reasonable person tries to run the barricade, or whether a person tries to run the barricade, is kind of like a non-starter. It's like if the police actually say you're under arrest and they're trying to put cuffs on me, but I managed to somehow run away in the middle of this thing, then I was never seized at all. I mean, that doesn't really quite make sense. It's the shooting in the Wendy's parking lot in Atlanta, where they're trying to put cuffs on him and they couldn't quite do it, and they tackle him to the ground and he starts running away. Well, he was never seized at all. And also, apparently, when they shot him to stop him, that also is not a seizure or something. Now, I think that was legal, so that wasn't my point. Right.
I think it was legal, but the idea that wasn't an action at all is a very strange conclusion. Officer says you can't come this way, no further, as long as they don't. I don't know, man. It's weird.
And I think that's indicative of the strength of her argument is how ludicrous of a situation you need to start saying maybe this doesn't apply. I mean, for Alito or whatever, it's a sniper 1,000 yards away. For Gorsuch, it's a barricade with an 80s style police force, an 80s movie police force.
But the sniper just scrapes me. Just scrapes me. So it doesn't really matter.
I just got grazed by a 50 cal.
Yeah. I suppose that's possible. I suppose a 50 cal could just graze you and it wouldn't be that big a deal. I wouldn't try it, but theoretically, maybe.
Don't let me get grazed by a Bushmaster. That's all I'm saying. I don't want that in my life.
Yeah. All right. So that was the argument from the petitioner. So next up, we have the United States government arguing for vacating it. So they were not happy. So next we have the U.S. government arguing their side of the case. So and then we'll hear from the other side, then from the police officers. So the United States here is an amicus curiae. So they're here as a offer thoughts. No,
to summarize, I'm clearly on the side of the people who think that a police officer shooting you is a seizure for the purposes of the Fourth Amendment. Whether or not, and to make a very important distinction under the law, a police officer shooting you may be reasonable under the circumstances and therefore justified under the Fourth Amendment. That doesn't mean that
because that doesn't mean just because it's a seizure doesn't mean it wasn't unconstitutional. You can have constitutional seizures.
Right. You do all the time.
Yeah, all the time. Right. The police seized you. Great. It wasn't constitutional or not. Next step of the analysis, Yeah. So yeah, but they never seized you because they didn't actually succeed. A reasonable person being shot at probably would feel like, that they're being threatened in some way and they're not really totally free. But they got away, so it doesn't really count. Okay. So what does the United States government wish to share with us? Okay, let's hear from Ms. Tableson, who wants to share some thoughts on behalf of the U.S. government. Okay.
Mr. Chief Justice, and may it please the court. In California against Hodari D., this court explained that a person is seized within the meaning of the Fourth Amendment when the police intentionally apply restraining physical force to his body. If the subject does not stop, the seizure lasts only a moment, the moment of physical impact, and may have limited implications. Like any seizure, though, it must be reasonable. For nearly 30 years, Hodari D has provided a clear and administrable rule to determine when physical contact between an officer and a citizen implicates the Fourth Amendment. This case requires the court only to reaffirm that rule. The facts of this case make it an easy one under Hodari D. It is undisputed that officers shot Ms. Torres as part of an effort to stop her and to stop her vehicle. She was therefore seized. But she did not stop, and so the seizure was momentary. Whether that seizure was constitutional and whether respondents may be civilly liable in this case are questions that should be answered on remand under the Fourth Amendment. This court should therefore vacate the decision below.
Yeah, I think that's completely right. Is basically, yeah, were the police within their rights to use force? Maybe we haven't gone that far. Was this a legal seizure? Maybe. Even if it wasn't, then we're into the second part of the qualified immunity analysis. Was it clearly established? Well, we already know the answer to that one. How could it possibly be? Because we're here trying to figure out whether it should be. But yeah, this is right. The idea it's not a seizure at all is a very strange argument. It's a seizure. Go figure out if it's constitutional and proper. Right.
Okay, so now we have the two sides. Now I'm confused about what's being argued. I thought we were arguing over whether or not this was a seizure in the first place.
This is an amici. This is not the second side.
Okay.
Yeah.
Here I am. I'm like, we're on the same side. This doesn't make sense. Okay, sorry.
Yeah. The U.S. government also has some thoughts. Yeah. So we're here with the amici from the Solicitor General's office. We'll get to the other side in a minute.
I can't wait for the U.S. government's argument that is somehow not a seizure. That's what I'm looking forward to.
Yeah, it wasn't because it wasn't the U.S. government. It's going to be
Arizona or whatever.
Yeah, it's going to be these random Arizona officers, presumably. So yeah, what their arguments should be entertaining. We haven't gotten that far yet.
Right.
So I wondered if there was some tension between your position and Ms. Corcoran's. Several times in your brief, you talk about.
Okay, I see it coming up on screen, and I'm sorry to pause, but it's coming up on screen.
It's okay.
Where Justice Roberts is about to ask this question that I have pinned a central part of my legal eagle analysis on. So he's about to ask about this tap on the shoulder, and I just want to talk to you. So is the tap on the shoulder going to be a battery or something? So if this could completely destruct my Captain Marvel analysis, and I may have to take everything back. So yeah, Justice Roberts is asking the core question: does the tap on the shoulder, is that okay? All right, we'll see what he says.
I want to just say,
I'm bracing myself.
No matter what happens in this case, your Captain Marvel assessment is spot on, because we're talking not about whether or not a battery occurred, but whether the responsive force was proportional.
Yeah, there were many problems. It's like first of all, a battery didn't occur, and even if it did, the threat has passed, and even if it hadn't, her amount of response was excessive, and even if it wasn't, taking the jacket is a robbery, and taking the bike is a Grand Theft Auto. So, like, at every step of the analysis, it was wrong. But we have to figure out whether I screwed up the first step of the analysis of this does not a battery make. Merely pulling down the paper does not a battery make. Will Justice Roberts disagree with me? We'll find out.
That the touch can be too light to qualify as a seizure. I'm looking at, for example, page 13, where you say, tapping somebody on the shoulder and asking for immigration paperwork would not constitute a seizure, and that the contact must be designed to restrain movement. Is there any distinction between your view of that and Ms. Corcoran's?
Mr. Chief Justice, I'm not sure there's a distinction between our position and petitioners. I'm not sure petitioners take an explicit position on those fleeting, non-restraining physical touches, but we do think that an important restriction on the test, and a restriction that is reflected in Hodari D, is that the physical touch must reflect an effort to restrain movement. That is consistent with this court's decision in INS against Delgado, which, as you referenced, involves the shoulder tap. Hodari D includes that restriction in defining a seizure, and the common law sources cited in Hodari D are consistent with that restriction.
So if there's a tap on the shoulder and the officer says, I don't mean to hold you up, you're free to go, but, I want to talk to you about this. Does that qualify as a seizure?
No, Your Honor.
Woo! I don't have to. Yeah, the U.S. government agrees with me. Merely the tap on the shoulder does not seizure make. Booyah! Booyah!
No, because of course the ultimate underlying question is would a reasonable person under the circumstances feel free to leave? If an officer tells you you're free to go, you are free to go until they indicate contrary to what they say, which they can do, by the way. If an officer says you're free to leave while bear hugging you, you're not free to go. They can't just say it's like yelling, "Am I being detained?" That doesn't do anything if you're
Okay, thank you, counsel. Justice Thomas?
Counsel, I'm a bit confused. Hodari D did not hold that there was a seizure, did it?
On the facts of the Hodari D case, no, there was no seizure.
So this was an individual who had thrown drugs away and then was later tackled, right?
Correct, Your Honor.
So I don't see how, on those facts, the some of the language in Hodari D can do as much work as you seem to be requiring it to do.
Oh, Justice Thomas, the question Hodari D was whether Hodari, a child, was seized at the moment that he discarded his drugs, which was before he was tackled. There was no dispute that he was seized in the tackling, but because at the moment he discarded his drugs, no police officer had touched him in any way, the court determined that he was not seized at that time.
But the seizure after the tackling and the submission or the control was the only seizure there. So I don't know. You seem to be using your definition, or at least the explanation in Hodari for what constituted a seizure when there was a finding that there was no seizure there as a basis for your argument. Anyway, let me move on to your case law. Can you think of a single case at common law where there was a touching by an inanimate object, for example, a projectile, that did not result in the submission that constituted a seizure?
No, I don't have a case precisely like that, Justice Thomas. I think my friend mentioned the Countess of Rutland's case from 1604, in which there was an indirect touching, but in that case, the Countess, who was the arrestee, did submit to the arrest, and so she didn't flee. That being said, the language in Countess of Rutland's case indicates that the touching through the mace alone was what affected the arrest.
Thank you.
Justice Breyer?
No, go ahead. Thank you very much.
Wow.
Justice Alito?
Maybe you can clarify something for me about your position. Let's say that the petitioner in this case had been struck by one bullet. For what period of time would she have been seized, in your view?
Justice Alito, she would have been seized at the moment of impact of the bullet, and that is all.
And that's it. Okay. So this is what really confuses me about your position. At the bottom of page 18 of your brief, you say that any damages claimed in a civil suit would be limited to harms traceable to the brief moment of the seizure. I would have thought that the damages in a case like this, if this is a valid claim, would constitute the effects of having been shot. Medical expenses, pain and suffering, lost income, and all that sort of thing. Could you explain what you meant by that statement?
All right, I'm gonna lost-plain this now to Justice Alito because apparently he doesn't understand how English works. All right, so let's scroll this back up.
Maybe he just wants her on the record doing this explanation.
Maybe because he apparently doesn't understand how English works. So I'm gonna explain it to Justice Alito like he's a moron. All right, so he says, "What is the period of time that you'd be seized?" She says, He would have been seized at the moment of the impact of the bullet, and that's all. So the period of the seizure is the impact of the bullet. Great, right. Understood. And he says, okay, that's what confuses me. He's like, really? Why? Apparently, in her brief, she says any damages claimed in a civil suit would be limited to harms, and this is where he apparently fails to understand English, traceable to the brief moment of the seizure. Correct. Yes. Correct. That is where the harm is traceable to this. So what was the seizure? The being shot, the harms that are traceable to that. And then he says, I would have thought damages in this case, if it's valid, would have constituted things like medical expenses, pain, suffering, lost income, and all that sort of thing. Could you explain this? Well, presumably all these are traceable to the being shot. Wow. Yeah. It's so weird because if we were in a criminal context, it's like I shoot someone else and a year later they die. It's like, well, if that's traceable to the bullet I shot you with, guess what, campers? I'm guilty of murder. You don't necessarily have to die immediately. Oh,
not anymore.
He died. He died 5 days later on the operating table. That doesn't really count. So can you explain this confusion? Because I thought it would have covered medical expenses and stuff. And it's like, what part of traceable to it did you not understand?
No, only brainstem direct hits are now murder because anything else is not does not happen sometime shortly after the momentous impact of the bullet.
Okay, well, so Justice Alito apparently doesn't understand words. Let's carry on.
Of course, Justice Alito. What we meant to say was that in many cases,
said it right the first time,
fleeting physical force seizure will be something that's far less than a bullet. And so, for example, if an officer grasps at subject's arm and the subject wriggles out of the grasp, that is a seizure under the Fourth Amendment, but it's not the type of seizure that could sustain meaningful damages under Section 1983. Of course, in this case, the seizure is not that. The seizure was
it couldn't really sustain meaningful damages in just a private tort context either. Right. if Nick over here grabs me by the arm and assuming that he did so improperly, my claim would be pursuant to whatever damages, which probably not a lot. So even assuming he's in the wrong, what we normally call this is nominal. It's like I'll sue you for $1.
You get
literally
declaratory relief.
$1.
Declaratory relief where the judge acts like mom and says, don't do that again.
Dollar to literally holla. Dollar holla, nominal damages, and that's about all. But once again, bullet, it's traceable. Yeah, okay, great.
Bullet to Ms. Torres' body. And so we do think that, that is the moment of seizure that should be analyzed, the bullet, for the purposes of damages under 1983 in this case.
Well, I still don't understand what that means in concrete terms.
Really?
Certainly her injury is traceable to having been shot. Is it traceable to the brief moment of the seizure, which is what you say in your brief?
What?
We think the brief moment of seizure is the bullet entering Ms. Torres' body. So I think they are one and the same for the purpose of this.
Can she get damages for, let's say, pain and suffering? Yes or no?
Yes.
Yes.
Yes, Your Honor, assuming that the tort principles that govern under Section 1983 would provide for such damages.
He seems to think there's a difference between the idea of it's traceable to the bullet versus it's traceable to the moment of getting shot. That's the only distinction he seems to be getting. It's like, because he says, what exactly did he say?
It didn't seem smart. Traceable to the having been shot.
Yeah, so certainly her injury is traceable to having been shot. Correct. And then he says, is it traceable to the brief moment of the seizure? When the brief moment of the seizure is the getting shot, what's the difference?
I guess, is there a weird, is he trying to work through a weird idea that the bullet entering the body is somehow distinct? Like the seizure has ended prior to the damage of the bullet being done? So I guess in theory, maybe taking it out of the context of the bullet thing, I'm being very generous with this, trying to get to where he is. But let's say you throw a rock at someone, right? Instead of a bullet, and the rock maybe leaves a minor bruise or something, but because the rock struck them, they fall. Or you throw a stick between their legs. So the seizure is the stick making contact, and that is the moment of the seizure. And then almost immediately after that, they fall and hit their head on the ground and get a concussion. And so maybe they're saying that the injury is from the head hitting the ground, which is post-seizure, because the seizure is the stick making contact with the body. And so he's suggesting perhaps that the bullet is the seizure, but the injury comes after the moment of seizure. Maybe. I don't know. That's the only thing I can think. And I think it's stupid, to be clear. But
yeah, I mean, there's probably some sort of proximate cause idea in there somewhere, as there would be in torts. So, I throw the rock, which causes you to stumble and causes, and somewhere down the line becomes too attenuated to my underlying action for there be further liability. That's Paul's graph, basically. It's just so attenuated. It doesn't, at some point, stops counting. But the bullet caused the medical. It's like the attenuation doesn't seem a lot there. It's like, so whatever the limits of the idea you're exploring, I'm not quite sure.
Look, I'm exploring the weirdness of the idea only due to the extreme weirdness of the question.
No, you and I are both trying to make the question make sense, and it's not really working. And we're like, okay, seems like a strange idea. It's attributable to the bullet hitting you, not attributable to the brief moment of your seizure. So okay. Sure, let's go with that, I guess. Carrying on.
Justice Sotomayor?
Counsel, you rely, as does your friend, on Hodari D.
Your friend.
Both of you believe, I think, and if I'm wrong,
you know full well that that's very common behavior in court. When you're referring to someone else, I will refer to my worthy opposition from the other side. I refer to my friend on the opposition. Yeah, this kind of language is typical. What are you giving a hard time for?
Look, after those Alito questions, I think both of them will be friends at the bar later.
Yeah, really.
Let me know that the language in Hodari is not dicta. Could you articulate why you think it's not dicta?
Justice Sotomayor, the facts of Hodari D did not involve a physical force seizure at the moment in question in that case. So I suppose you could imagine the court in Hodari D having resolved the question presented there on different reasoning, but that is not what the Hodari D court did. Instead, the court expressly framed the question presented as whether, with respect to a show of authority, as with respect to application of physical force, a seizure occurs even though the subject does not yield. The court then has a long discussion of physical force seizure and specifically concludes that the application of restraining physical force, even if unsuccessful, can be a seizure. That language has never been abrogated, and that particular point was agreed to by the dissent. So we take the Hodari D court at its word, and Hodari D did establish a clear and administrable line that has been in place for 30 years. So we are not asking the court to revisit that language in Hodari D today.
It seems somewhat logical. It was necessary to the reasoning of the court in reaching its decision.
We certainly don't think it's language that we could simply set aside. Of course, we advocated for a different position in Hodari D. This court rejected it, and so we are here respecting, the court's precedent in Hodari D.
Thank you, counsel.
Justice Kagan?
Ms. Tableson, I wanted to ask you about exactly that question that you just said at the end, because your office did take a different view in Hodari D. This question was viewed as important to the resolution of the case there, and the office said, and I'm quoting here, at common law, the concept that someone could be in flight and yet also be seized would have been unfathomable. So this is not a criticism of a change of position. I just want to understand what accounts for the change of position in this case.
Yes, Your Honor. If you read our brief in Hodari D and then you read the decision in Hodari D, it's quite clear that this court considered and rejected the government's position, both the bottom line and the reasoning and the inferences that we drew from the common law. So we didn't certainly feel comfortable simply, running it back. It's also true that, as I sort of alluded to before, for the last 30 years, Hodari D has provided a clear and administrable standard to determine when these interactions between a police officer and a citizen rise to the level of the Fourth Amendment. And the United States' interest here is in establishing a clear and predictable rule that law enforcement can apply in the heat of the moment in the field. And we think the rule established in Hodari D achieves those ends.
And Ms. Tableson, along the lines of one of the Chief Justice's questions, I mean, is there anything that Petitioner's counsel said in her argument, or for that matter, in her brief, with which the government disagrees?
No, Your Honor. The one thing I would say is that Petitioner's brief does not take an express position on how to analyze the intent required for a fleeting physical force seizure. And we have tried to emphasize that that's an objective inquiry under this court cases. So that's I wouldn't say a disagreement, but rather a slight difference between Petitioner's position and ours.
Thank you, Ms. Tableson.
I liked her answer. It's like 30 years ago, the U.S. government advocated for something different. What changed? Well, also 30 years ago, the Supreme Court said we were wrong. And so we took the Supreme Court at its word. And now we're basing our opinion based on what the Supreme Court told us. That would be a thing that changed.
The other thing I like is her focus on the clear and administrable decision, because police officers, as she's alluding to in the field, need to know that when you touch someone, you have made a seizure in the purpose of apprehension or whatever, that you actually have made a seizure, because police officers do understand usually that there is a different set of rules when you're dealing with someone who is seized for the purposes of the Fourth Amendment and who is not seized. And so knowing when that line is actually crossed at the moment of impact and for how long it's crossed is very important. If someone, and breaking this down, this argument makes all of the sense in the world. If they apprehend someone for a day, they are seized for the entire day. If that person files their way out of the jail bars and climbs out the window, they're no longer seized by the police. So it only makes sense that any physical force which is intended to restrain someone does, in fact, seize them for the brief period in which that force is applied. It must. It necessarily must. The fact that it's a moment versus a day versus a week versus an hour is irrelevant. It's just we're talking about scale at that point, not in function.
And again, this idea that this seems like it would just be the law as it applies to you and me, and the law and common law. It's like the amount the time frame of what was done is not really the issue. It's like the amount of harm that happened. You know, some things might go on for days and not be particularly harmful. Some things might last for a moment and be very, very harmful. So if you did something to me that lasted for days and days and days, it may not necessarily be redressable. If you did, because maybe there's no damage in the end. But if you did something that was, like shooting me, for example, then presumably, even though it was very brief, the shooting, I should be able to get damages for all the things that reasonably flow from that, because that would be your responsibility. And so, if the police seized you for 30 years or a year or a day or how long a bullet takes to do its magic, probably about 2 seconds tops. That doesn't really matter. What really matters is the amount of damages. And and then of course we can get into the issues about like whether or not it was legal, whether or not it was proper, whether or not it was just, and all the rest of it. But the idea that there's no seizure at all because it only lasted for a second, like weird.
Very weird.
Yeah. And I'd just like to take a brief moment here to pause, and I'll of course say it again by the end of the stream. But I just want to thank the 733 people that are currently watching the stream live. Woo! I really, really appreciate it. That's other than when I was doing some streaming related to the Judge Flynn motion to dismiss, in which my soul left my body because it went on forever. But other than that, this is a record for my channel for 730 people watching.
Hey.
So I just want to say thank you. A year ago, December the 30th of last year, I think I was at 2,800 subscribers, and now I'm at 18,000. So we've gained, 15,000 subscribers this year, give or take. And I want to thank all the people that I've had the privilege to have these conversations with. Whether it's Leonard French or Nick, or it's Nate the lawyer, or Viva Frey, and I look forward to hopefully having more in the future. It's been a pleasure. So from me to you, I thank you giving me the opportunity to try to talk about something I really, really love. So I appreciate it.
Well, congrats, man. That's awesome.
I know we're making progress. All right, let's listen to a little bit more of this argument.
Justice Gorsuch?
Counsel, in terms of clear and administrable lines, the Fourth Amendment, as interpreted by this court, the seizures of papers require actual control, effects, actual control, show of force under Hodari D, actual control. Here alone, this is an anomaly, isn't it?
Yes, Your Honor, and I think that's one of the arguments we made in our brief in Hodari D. That being said, in the show of authority...
If that's the case, I guess I'm curious, what authority do you have in terms of the original and ordinary meaning of the word seizure at the time of the Fourth Amendment that would countenance that difference? And how, I guess you're going to tell me that incorporates arrest doctrine, but how do we know that? And on what authority do we have for that? The founders were well aware of the word seizure and well aware of the word arrest, and they deliberately did not use arrest, it seems. Why should we incorporate Dickensian debt collection practices, which were enabled by a very liberal view of arrest to allow somebody to reach through a window, grab somebody? Why should we incorporate those practices into the term seizure?
This court has recognized again and again that an arrest is the quintessential seizure of the person. That's in Payton as well as Hodari D. And this court has also consistently looked to common law cases to help inform the meaning of the Fourth Amendment, including civil cases. Entick against Carrington, of course, which is one of the hallmark common law cases the court has looked to in defining the Fourth Amendment, was a civil trespass case. We do agree that the common law rule arose in a different context from the one that we're talking about here. But what the common law and the Fourth Amendment have in common.
If we're going to do the common law of arrest, I thought I heard you disagree with your friend earlier. And
not my friend, guy.
It's pretty hard to find a case involving a projectile that constitutes an arrest, even under the very liberal Dickensian type debt collection practices cases.
I'm not exactly an expert on the life and times in Dickensian England, but although I'm sure guns did exist and were used, I don't know that they were used typically by citizens, because at this period of time, these are private arrests by individual citizens. So were they typically used by private citizens in Dickensian workhouses? So maybe that's why we don't have any cases on it.
And weren't at some point, and maybe it wasn't not knowing the period of Dickensian debt collection, but at some point, wasn't there a gun confiscation or severe reduction in guns by the populace in England?
Yeah, that
around
happened.
that time. So it's the interesting thing. I meant to talk about this a little bit earlier. Is just because we don't have cases where someone is shot by police and then is successful in fleeing, and then there being a question constitutionally of whether or not a seizure was in effect during that time, that's because it's a really unlikely circumstance for all of those things to line up in a place that would be a case that would then subsequently make it to the Supreme Court level. Like, you have to have a gunshot by a police officer of a fleeing suspect or someone prospectively being arrested who is struck by the bullet, who does not perish, who succeeds in fleeing, who then has a cognizable claim either under a 1983 injury claim like we have here for unreasonable force, or has a cognizable claim for some other violation that would occur during the seizure, maybe questions without properly notifying them of their rights, or Mirandizing, as commonly stated. Like, we have to get so many levels, and again, someone who ends up fleeing can't be questioned probably during the moment that they're struck by the bullet. So, like, there's a logical difference where a very limited set of facts can actually get to this type of situation. So the fact that it maybe didn't occur very often. Isn't that weird? And especially when we're talking about 1600s musket technology, like the farther someone gets away from you beyond a few yards, the less likely you are to hit them in the first place. So he's really hammering down on this, but it's like, buddy, it's just unlikely.
I know the holiday season is upon us. Have we been rereading A Christmas Carol or something? That's on the top of our mind. Is that what's going on?
It's like, if you got shot in the 1600s, usually, like a lot of times you didn't make it because you got an infection and died.
Yeah, no, in fact, infections were by far and away the major killers in antiquity. It's like the amount of people died of infections are amazing. Antibiotics were a miracle. Yeah, and
we should ask Alito if the infection's traceable to the musket.
Yeah, that'll be good. And as they're gonna say, it's like, yeah, guns weren't really used in the course of arrest normally in the day, and maybe that's. So, what is the big brain takeaway the other directions? So, guns weren't used a lot, therefore they're not in the common law a lot. Therefore, there aren't a lot of Fourth Amendment cases in common law dealing with impropriety of gun seizures. Therefore, all guns are good because there's no in common law. So, no matter how many times the police shoot you, we're all good because there can't be a common law case on this. It's like, what is this? What is this logic going on here?
Why use handcuffs? Just shoot them.
Yeah. I thought the Supreme Court told me that's bad. I don't know. Maybe we're revisiting that. I don't know.
You're free to leave. Blam, blam, blam. They weren't ever arrested. They're just dead. And we have qualified immunity for it.
That's true, Your Honor. There's not a gun shooting or a projectile flying through the air case that I'm aware of.
Guns were unknown at the time, right?
I think I agree with my friend that guns were not regularly used in the course of an arrest at the time.
They were not unknown either,
Justice Kavanaugh.
Thank you, Chief Justice, and good morning, Ms. Tableson. On your brief in Hidari D., the Solicitor General's brief said that the historical evidence defined the term seizure as requiring actual control over the person or thing seized. And the brief said, as a matter of original understanding, one could not be arrested or seized until he was in the physical custody of the seizer and within his control. The court in Hidari D., as you point out, did not adopt that position. But was the court wrong about the original understanding? In other words, who's correct about the original understanding, the Solicitor General's brief or Justice Scalia's opinion for the court?
Oh, this is fun. So Justice Kavanaugh here is basically alluding to the idea that Justice Scalia, when he authored this opinion 30 years ago, did not have the correct originalist understanding. And so Kavanaugh's looking to overturn Scalia for getting the originalism wrong. Wow, that's kind of a bold move there.
The Hodari decision makes infinitely more sense immediately now that I know Scalia wrote it. We're talking about these sort of brief attenuated moments because he's a stickler on stuff like that. Like we said in US v. Jones or whatever. That was a Scalia decision. It was the same thing. They hooked a GPS device onto a car. And I was really annoyed at Scalia for that decision because I wanted him to come to the conclusion that following you, following your car everywhere you go is in and of itself a violation of your Fourth Amendment rights because it's not merely a happenstance passing at an intersection. And if someone were to get in a car and drive behind you the entire way, that would be a deprivation of rights. But he doesn't do it.
Instead of going under the reasonable expectation, he said, let's make trespass great again.
Yep.
And so Kavanaugh over here is like, I know originalism better than Justice Scalia. He got it wrong 30 years ago. Who was right? The solicitor's brief or Justice Scalia, the fount of originalism 30 years ago, got this wrong, so we can overturn Scalia. Okay, that's good.
I like beer.
I suppose I like beer too. I also like, not being shot by the police, but that's me.
Well, Your Honor, our brief in Hodari D., to support that rule, cited many common law sources involving the seizures of goods, such as ships, in which the seizure was consummated with control over the item. And what Hodari D. said was that is not quite the right source of law to look to in analyzing the seizure of a person, which is the arrest. And it's true that even in our Hodari D. brief, we cited some sources indicating that an arrest could be complete at the point of mere touching. So at this point, we take Justice Scalia's opinion in Hodari D at its word, and we're not asking the court to revisit the original meaning of a seizure under the Fourth Amendment.
I just want to make sure, are you saying Justice Scalia it's not only precedent, but Justice Scalia was right? Or are you not saying that?
I'm saying I think Justice Scalia drew a distinction between the common law sources that is accurate and that you could even potentially see in our Hodari brief if you squint. So yes, I think he was right.
Thank you.
Okay.
A minute to wrap up, Ms. Tableson.
Thank you, Mr. Chief Justice. Under this court's precedents, the intentional application of restraining physical force to a subject's body, even when that force is unsuccessful, is a seizure. And the seizure lasts for as long as the physical force is being applied. There is simply no other way to read Hodari D. This court has never called Hodari D into doubt, nor has it ever decided a case whose result goes the other way. This court has also repeatedly emphasized that the Fourth Amendment analysis is an objective one. The Hodari D test focuses not on an officer's mental state, but rather on how a reasonable person would have understood his conduct. Under that test, Ms. Torres was seized, albeit briefly, so the Fourth Amendment applies. But as in any case, the fact that a seizure occurred is the beginning and not the end of the Fourth Amendment inquiry. This court should vacate and remand so that the courts below may apply the reasonableness standard and analyze qualified immunity. Thank you.
Thank you, counsel. Mr. Standridge.
All right. So before we move on to the people saying how this wasn't a seizure and the police shooting you is totally cool, any particular thoughts on the U.S. government's position?
On what on the Solicitor General that they just said?
Yeah.
No, I think it's accurate. I think they ate their humble pie 30 years ago. Scalia probably excoriated them a little bit in his opinion, and they're now coming back. And I think one of the only thing I think she didn't do forcefully enough, and I think the other lawyer didn't do forcefully enough, is to maybe just go back at the judges for a moment and say, we can actually see no reason why this court should revisit or should ignore stare decisis in this case. Like, just hammer home that not only is this precedential, you have this court doctrine, and overcoming stare decisis is a massive undertaking, and this case is certainly not the candidate to do it. I think just hammering that in a little bit more would be my only mild criticism, but I think her argument was quite good.
Yeah, I totally agree. All right, so now we're going to listen to the villain of the piece explain to us why this was not a why shooting at them and striking them was somehow not a seizure. So let's see how that argument goes for Mr. Standridge. Okay, Mark, what you got for us?
Mr. Chief Justice, and may it please the court. A seizure under the Fourth Amendment occurs when a police officer acquires physical possession, custody, or control over a suspect. From the time of the founding to the present, and as a matter of common sense, the acquisition of physical control over a person has been necessary to effectuate a seizure. Whatever the means employed by the police, the endpoint is the same. The police action must result in the officer's acquisition of custody over the person, terminating the person's movement. In other words, the suspect must be stopped by the very instrumentality set in motion or put in place by the police officer. Petitioner Roxanne Torres was not seized by either Janice Madrid or Richard Williamson on July 15, 2014. While these officers shot at and hit Petitioner, they did not acquire physical custody or control over her. Petitioner did not stop or even slow down in response to being shot. Instead, she fled the scene, stole another vehicle, sped 75 miles west of Albuquerque, New Mexico, and eluded arrest for over a full day. The fundamental flaw in the petitioner's argument here is that at no time did the officers acquire possession, custody, or control over her. Indeed, petitioner never stopped in response to the police action. As the officers did not seize petitioner, they cannot be held liable to her for excessive force in violation of the Fourth Amendment. The 10th Circuit correctly held as much below, and its decision must be affirmed. Mr. Chief Justice, I look forward to the court's questions.
Yeah.
Okay.
So we're back to as long as the police only cause a flesh wound, as long as you're able to, they can shoot you, and as long as you're able to limp away or something, that doesn't really count.
Yeah. His argument goes into the bizarre on its face when he says that they cannot be liable for excessive force in shooting you if you don't stop, which is nonsensical. Just from that'd be like saying, I guess if they beat Rodney King as bad as they did, and then he got up and left, that it would have been okay.
Doesn't really count. He was never in their possession or control.
Right. And I would argue
he was free to leave at any time.
And of course, a bullet entering your body is necessarily an exertion of control over what happens next. Because no matter what, even if it's merely to put a bandage on as a grazing wound, that is an action you did not otherwise have to take or would have otherwise even considered taking in the alternative. There is a measure of control that is affected by a bullet entering your body in the same way that there's a measure of control affected by a nightstick hitting you in the head, even if you were to proceed to run away afterwards. And the question, what they're trying to do is muddy the line between the idea that excessive force occurs here and the justifiability of the flight that occurred afterwards. So if her flight is unjustified from police after the bullets, that's a different question than whether or not she seized at the time of the bullet's entry into her body, in my opinion.
Yeah, and as we were pointing out, just even getting to the next step of she was seized doesn't necessarily mean it was an unreasonable seizure. It doesn't mean the police are in the wrong. We haven't gone that far. So neither of us are saying that we have concluded that she's able to recover. We think it's a seizure. Whether or not it's unreasonable, it's at least based on the facts as presented by Oye, at least on the superficial facts, it doesn't sound unreasonable. Maybe it was when they get into details, but we could get into that. But the idea that there never was a seizure at all, it's like you're trying to gain control of them. You caused them an injury. You trespassed onto them. It's like, it's just so weird.
It's so strange.
This is just going to be another Kansas v. Glover, isn't it? I'm gonna be wrong, and it's going to be an 8-1 vote of that shooting people is totally cool if you're the police. I'm going to be wrong and mystified.
It's a baffling position. The idea that police officers are immune from liability for shooting someone under any circumstances, because that's the ultimate question. If they're not liable for the excessive force, then they have qualified immunity, right? Like that's the underlying result in this case, I would assume.
Yeah.
So it's that, but the question here is, do they even get to challenge the propriety of shooting? That's what we're trying to figure out. So that's what this case is about, is do they even get to say shooting me might not have been right? So it's great. I love it.
Mr. Standridge, I'd like to follow up with some of the questions that Justice Gorsuch asked of your friend. There are a lot of cases about private citizens, mere touches and all that, that nonetheless are held to constitute an arrest.
Right.
Is that the same? Is there any reason we shouldn't translate those into a police affecting a seizure?
Absolutely, Mr. Chief Justice. We should not translate that body of case law cited by the petitioner regarding the mere touch rule, because it arose in a very limited and narrow context. As the court has pointed out repeatedly today, it arose in the context of Dickensian debt collection practices existing in the late 18th century. The constabulary and the bailiffs of the late 18th century are far different from our modern police force of today. In fact, as petitioner pointed out, we didn't have public modern police forces until the mid-19th century.
This is such a weird argument, because if you take it to its logical conclusion, it would imply, because we didn't have modern police forces until the mid-19th century, then whatever was said about the Dickensian debt collection practices, sheriffs, bailiffs, whatever of old England are completely irrelevant today. So the Fourth Amendment can't be speaking to any of that stuff, because presumably under this logic, the Fourth Amendment would only be speaking to the Dickensian work practices or something, and couldn't possibly be speaking to modern police. So modern police are not subject to the Fourth Amendment or something.
Or any
amendment. Am I misreading this logical extension, Nick?
No, it seems like it's the Second Amendment argument all over again. It's, well, the founders couldn't have possibly fathomed a modern police force like we have today. But of course they did fathom it. they in fact specifically prohibited it under the federal from the federal police force standpoint in the Constitution. So and what he's asking does seem to be that, yes, modern police forces are not subject to constitutional restrictions, only statutory ones, I guess would be the idea, since modern police forces are created by statute and exist outside of Fourth Amendment considerations. And to take this to its logical conclusion would then say that that a modern police force searching and seizing you, of course, couldn't have been contemplated by the founders either, which is silly, because even if that were true, we have the 14th Amendment applying constitutional standards all the way back to municipalities which use a modern police force today. So this is all it's a very weird argument. And if he were right, it would undo everything we know about the interaction of law enforcement and the Constitution outside of very limited scopes.
I think your point on the Second Amendment was exactly right. The constables and bailiffs of the late 18th century are so far removed from modern police that it doesn't speak to modern police. So by that logic, the First Amendment doesn't speak to not only Facebook, but let's go television, radio, electronic communication,
printing press.
Anything more in printing press. Second Amendment doesn't apply to modern firearms because they were completely unknown. They can't apply to cars because cars were completely unknown. This logical position, if you take this position as a predicate, basically undermines the entirety of the Bill of Rights, it seems like to me. I don't think that's too much of a reach. So, okay. The modern police aren't subject to the rules of the constables and bailiffs for some reason. All right, that's okay.
But I thought our cases made clear that the Fourth Amendment was designed to protect at least the level of bodily integrity, personal security that was secured at common law. Is there and our cases certainly look to common law precedents about arrest, even if by Dickens or anybody else. And what authority do you have for that distinction?
Your Honor, I'd cite first at Peyton versus New York, this court's opinion where the court noted that the common law rules of arrest developed in legal contexts that substantially differ from the cases that the court sees before it today. That these important differences between the common law rules that existed relating to arrests at the time of the framing and those that have evolved through the process of interpreting the Fourth Amendment in light of contemporary norms and contemporary conditions require that we depart, that we reject historic relics that are not suited to the modern era. The part-time constabulary that was in charge of ferreting out debtors and bringing them back before the court, it's simply different from what we expect of police officers working today. Our public dedicated police force is there to arrest or to investigate and make arrests for crimes.
What?
So his argument is saying that because the role of the constabulary in bringing in debtors is so significantly different from the criminal investigative power of modern police, that we should allow police to shoot people. Like, when you get down to it, that's what his argument is actually saying.
He's talking about contemporary norms and contemporary conditions. We're like full bore living constitutionalism over here. The contemporary reality is so different that we don't need to worry about those things, because the pesky Constitution was dealing with things, and so we can have a contemporary modern understanding with our sophisticated, refined police forces, which, you know, given the number of qualified immunity cases I cover on this channel, I think we might have to have some quibbles with. But it's so different. I can't even remember the last time someone went to the Supreme Court and said, how about some living constitutionalism? How about some of that?
But even the living constitution approach doesn't really support the conclusion he's looking for, because the idea is that typically the idea of living constitutionalism is that as we modernize, we become more sensible. And the more sensible approach would be not to allow police officers to shoot people. Like, if you take this to its logical conclusion, existing in contemporary Western countries like the UK, you have most police members outside of special units not even being allowed to carry a gun for the risks that it poses to the populace. So, like, the progressive living constitutional approach would still favor not allowing police to shoot. And in fact, many jurisdictions would have training to suggest that you should not shoot at a fleeing vehicle because of the reckless danger that it would provide to the populace. This is a terrible argument either way for him, in my opinion. But I mean, I don't know where you go with this argument. Maybe I'm biased, but this seems bad.
I mean, it feels like there's got to be a way to make this other argument other than the track he's going down. That it doesn't qualify as a seizure because they weren't stopped. I'm like, okay, but our police forces of today, they're so modern that's wow. Okay, fine. Let's press on, and as I need to reach for some whiskey or something, because that's where we're heading rapidly.
What you emphasized the fact that Ms. Torres drove on and wasn't actually apprehended, I guess.
Robert's trying to get him back to it
for a day. But what if she hadn't been able to continue on, or what if she was able to drive on only for a couple hundred yards? Would your conclusion be any different?
I would say that if Ms. Torres stopped within a reasonable distance, within maybe 50 feet or a half a block from the scene of the shooting, allowing a reasonable police officer, allowing a reasonable amount of time for the police to go and acquire control over her as a result of them shooting her and stopping her, then yes, that certainly would constitute a seizure. But
can we pause?
This set of facts from an objective.
Okay. What he just proposed is 3 objective tests in the process of determining whether a seizure is about to occur, rather than merely deciding whether the seizure occurs at the time the bullet enters the body with a simple test, not an objective test, no reasonableness necessary. But he went reasonable person, or a reasonable stop, a distance for a reasonable police officer to, in a reasonable amount of time, affect the seizure, which is, again, that's 3 tests. When what the other proposal is much simpler to administer. And I think this administration argument may come in to be a great argument in the long run, is, wait, the bullet enters the body, they're seized for the moment the bullet's in the body, and they're no longer seized if they proceed on, don't stop. And then if she were to stop at any distance in which any officer were able to, in any amount of time, effect a seizure upon her, she is then seized again for the purposes of the 4th Amendment. There's no reasonableness test necessary. It's the most easily administrable system. She's seized when she's shot. then she's not seized, and then she's seized when she's apprehended.
I also like the very short distances of the reasonable distance, because it's 50 feet or half a block. If they make it a whole block, though, whoa,
right?
That's not a seizure. They made it from 9th to 10th Streets.
And you're gonna have to have a court hearing testimony about how fast they were going, the braking distance that was it reasonable for them to have stopped in this amount of time? Well, they didn't feel the bullet into their body because they were, they have a nerve disorder and it hit them in a non-vital location. So they didn't realize they needed to stop. So was it reasonable for them to go 2 miles before stopping when they felt blood on their shirt? Like nonsensical outcomes.
I've never had the experience, but I can at least imagine a person from adrenaline or whatever might not realize they've been shot or stabbed right away. I've definitely heard stories. Where people don't know they've been shot or stabbed. And like, okay, yeah, all right.
Yeah, you can talk to soldiers and police officers who have been shot or stabbed, and you'll get varying responses, of course, depending on the body's response to the situation. This is a crazy. Never mind. We got to go back to it.
Okay.
Standpoint. No reasonable person, no ordinary person, as a matter of common sense, could say that a person who is shot by the police but continues to drive well out of range, well out of their sight, and eludes them for a full day could be seized as a matter of the Fourth Amendment.
Thank you, counsel. Justice Thomas.
Thank you, Mr. Chief Justice. Mr. Standridge, I'd like you to, on Hodari D, I'd like you to give us your reasons for why some of that language that seems to dispose of this case in Hodari D is dicta.
Absolutely, Justice Thomas. The simple fact of the matter is that Hodari D did not involve a use of force, as did Brower versus County of Inyo and the present case. This court was not called upon. The facts of Hodari D did not involve a claim that police officers, in pursuing young Mr. Hodari D, touched him or got a hold of him at any point before he discarded the drugs. As the court pointed out, Mr. Hodari was not seized until he was tackled. It becomes a binary question. You are either seized and in control of the police or you are not. So the discussion about what may have occurred at common law, the possible factual permutations of when someone may have been arrested at common law, showed the outer bounds of what an arrest can be. But because that discussion was divorced from the facts of the Hodari D case, it is dicta and it is thus not binding on this court. The ultimate holding of Hodari D supports the 10th Circuit's reasoning below.
Are you familiar with any of the cases that have followed the reasoning that petitioner points to in Hodari D?
In terms of the circuits that have since looked at that bit of common law discussion and
exactly as a holding.
I am, Your Honor, and I would submit that those circuits, which were few and far between, were mistaken in applying that discussion as the actual holding of Hodari D.
When I asked Ms. Corcoran about someone being arrested merely by the touching of an inanimate object, I think she referred to, and I don't want to mischaracterize what she said, but I think she referred to the Countess Isabel of Rutland case in 1605. Are you familiar with that case?
I am.
Could you tell us what your take is as to whether or not that constitutes precedent for the mere touching with an inanimate object being the equivalent of an arrest?
I would say with respect to that case, Justice Thomas, that it too is divorced from the facts of this case. In fact, I think as the government just conceded in the Countess case, the officer, the bailiff, did touch the person with the end of the inanimate object, but that second step, the step of control, occurred when the person submitted to the authority. That's not true of this case.
So you're saying that the Countess was compelled to actually be taken to the compter and basically the equivalent of jail. So that would be the seizure. I tend to have read it that way too. Are there any cases that you've seen where the mere touch has been applied to someone outside of the criminal context, or in any of the cases that dealt with the criminal context at common law?
I have not, Your Honor.
Thank you.
Justice Breyer?
Morning. Suppose that a policeman, without a warrant, wants to search a private person's house, enters in the middle of the night. Before he can do anything, he doesn't look for a single thing. No chance to look for or search for anything. A big dog drives him out. Is that a search?
No, Your Honor. I would submit that it is not, because the officer, though he is entering.
Okay, but I have to go back to make sure I actually heard what we both heard.
That was the weird. Okay.
Suppose that a policeman without a warrant wants to search a private person's house, enters in the middle of the night. Before he can do anything, he doesn't look for a single thing. No chance to look or search for anything. A big dog drives him out. Is that a search?
Yes, of course it is. I say yes, of course that's a search. It just wasn't a productive search. Like, he's entered into a premise. Were he to do anything that would implicate the person, he would be in violation of the Fourth Amendment. Like, I don't even know.
Isn't it also a seizure because he's by being in possession of the home?
Yeah,
he's now in possession of the home, so he's at least seized part of the home. But yeah, it's blowing my minds collectively. It's like, okay, so yeah, in the middle of the night, this person without legal right to enter enters, and they are unable to do anything because the dog scares them away. It's like, okay, let's go one step more, just because why not? This officer, for reasons that, even though he has a desire to search, once he enters the house, he closes his eyes, and because of his bat-like sonar skills, I don't know, whatever, play with the hypothetical, he's walking around the house, and then he decides to leave, and apparently that also doesn't count or something. My mind is blown a little bit.
Yeah, because he's trying to make a distinction between the verb search, or to search, I guess, versus whether or not a search has occurred for purposes of the Fourth Amendment. But I think the moment he steps into the home, a search has occurred for the purposes of the Fourth Amendment. The extent of the search, the fruitfulness of the search are certainly variables to that, and they may both be zero, but he still has entered the home for the purposes of searching. That he doesn't find anything is merely, like, for one, let's ignore the impossibility of the hypothetical that he would be in the home somehow without in any way conducting a search. That's
he has
crazy.
No eyes to see. He has no ears to hear. He has dog senses now.
Yeah, because even something, so if you go with like a plain view or plain smell or plain hearing sort of theory to get around the Fourth Amendment, those are exceptions to the Fourth Amendment, admitting that a search has occurred. It's just that the reasonableness of the search is created by the obvious nature of the evidence. So the plain view doctrine is if you're in searching for something in a lawful way, or if you're in a place where you have let's say you invite a cop into your house for coffee and you have a bunch of cocaine on the table because it's the 80s, and they see the cocaine, then they don't need a search warrant to say this is in plain view and I'm lawfully able to be here. So, but that is an exception to the warrant requirement. That doesn't mean that a search doesn't occur. That just means that it's accepted and presumptively reasonable because they did it, because of the plain view. So I can't see in any way how Breyer's hypothetical is useful, because the mere act of entering is in and of itself a search. And again, the question is reasonableness at that point.
I mean, Justice Breyer, if they enter into your home in the middle of the night, does that not constitute a wrong? Immediately, one would imagine. If they, okay, I mean, it's, I don't, I'm confused. I'm very confused.
And one of your viewers brought up an interesting point, and I don't think it's specifically on, but it goes kind of to what I'm saying. A. Hedinger says, I think the search occurred when he entered the curtilage. And the reason the search occurs when you enter the curtilage is not because there's something special about the curtilage. It's because you're already searching. I mean, the very act of entering is a search. Like you can't shut up. You're not in a sensory deprivation helmet. Like as you enter the home, it's an impossibility. And you still could feel like he could feel a bong, for example, and he doesn't have to see or hear or smell for a search to be conducted. It's okay. Anyway, this is an annoying question.
The answer's annoying.
Yeah, the answer is worse.
Is it a search? No. Okay.
He didn't obtain information. So no search matters if you don't actually obtain information that you're looking for, which again is not how Fourth Amendment searches work. Because there's other considerations to and implications of a search than whether or not you found a thing. Like when you're being seized or searched for the purposes of the Fourth Amendment, there are specific processes and protections that go into place for the person. It changes the dynamic of the relationship necessarily. So search occurs prior to the obtaining of information. That's a post hoc, post facto, or whatever.
Into the home has not obtained information, and that's the hallmark of an invasive or an unreasonable search under the
invasive or unreasonable is different.
A police officer intending to search, breaking into somebody's house, has not committed a search unless he has a chance to look around. And to say something similar here, that doesn't seem to me to make the right of the people to be secure in their persons or houses from unreasonable searches and seizures much protection. Whole area, no protection at all.
What I would say to that, Justice Breyer, is that the seizure clause of the Fourth Amendment and the search clause of the Fourth Amendment do protect different interests. The seizure clause protects against unreasonable termination of a person's freedom of movement. It secures the right of the people to be secure in their persons, in their ability, in their liberty to move. The search clause is somewhat more broad. It protects against the idea that the government can enter into a house with a general warrant, search for whatever information it wants.
And if they don't search, it's not a search, because the big dog scared them off. Same harm. I mean, pretty bad harm. I mean,
it is and it may be actionable under some other provision of law. It may be
any authority that if you don't actually look around because you're scared off first, it's not a search.
Thank you.
I don't have that specific authority.
I would be surprised.
I would be surprised too, but just given my understanding of the difference between the seizure clause and the search clause, my understanding of this court's case law is that searches occur when
forget searches, because I'm trying to make a point.
Sure.
My point is you could read this Fourth Amendment as applying to attempts, because the same harm is there and it's attempted search, attempted seizure. But we haven't read it that way. And therefore, we need a line that's somewhat bigger than the one you propose. And Hodari and the others are an effort to draw that line, and it's as good a line as any. All right, your response.
I disagree with that, Your Honor. I think Hodari did draw the distinction between attempted seizures and actual seizures. And I think Brower set forth the hallmarks of what an actual seizure by physical force is. It's a stoppage of movement. It's termination of freedom. It is a taking possession. It's physical control. That is an easily administrable rule for police officers working in the field. And it's also easily understood by the common person. It comports with common sense and common understanding through 200 years of dictionary definitions and case law on the ordinary notion of seizure.
Thank you.
Justice Alito? Well, picking up on the ordinary notion of seizure, suppose a police officer is attempting to arrest someone, grabs that person's shirt and holds onto the shirt for a couple of seconds, and then the person breaks free, flees, and disappears. Has that person been seized?
That person has been seized, Justice Alito, for the matter of seconds under which they were under the control of the officer. If the officer, in grabbing the person's shirt, held the person in place for a non-zero amount of time, for a few seconds, at that point, it is a seizure. Again, it's a binary question. You are either under the control of the police officer or you are not. Once the person breaks free of the officer's grasp and runs away, the person has broken that seizure that might have existed for a few seconds.
So a seizure does not require the submission to the law enforcement officer, and it doesn't require that a person be permanently taken into custody. It simply requires that the person who is doing the seizing have control of that person for some period of time. Is that your understanding?
That is my understanding, Your Honor, that the officer acting with the intent to bring the person under their control actually then acquires that control. Those are the two necessary elements of a seizure.
You presumably, you certainly know more about New Mexico law than I do. Is there any reason why this could not have been brought as a battery claim under New Mexico law?
There's absolutely no reason, Your Honor. For reasons that are not clear in the record, this particular plaintiff filed her lawsuit directly in federal court after the statute of limitations had expired for state law claims under our sovereign immunity statute.
There's the reason.
She did file in time within the 3-year limitations period we allow for Section 1983 claims. But a more prudent course of action would have been to file not only the federal claim, but to also file a pendant claim for assault and or battery under New Mexico law. And as far as I can tell, there was no impediment here that would have precluded that.
Would the officers have had defenses under New Mexico law that are more generous than those that would be available under 1983?
I don't believe so, Your Honor. We do have a good faith defense that comes from New Mexico Supreme Court case law. However, New Mexico Supreme Court case law also counsels trial judges against granting summary judgment. We are a very summary judgment averse state. I believe I can represent as an officer of both this court and the state courts of New Mexico that it is likely an assault or battery claim brought by a petitioner or a plaintiff such as this petitioner would have survived summary judgment, would likely have to have been resolved at trial.
I mean, can we pause for just a second?
Yeah,
Counsel,
absolutely.
there is an element to the.
That's a bold claim to make. Like, well, we don't really like summary judgment, so this probably would have survived summary judgment. Is weird. The other weird part of that is saying that that she should have brought it in New Mexico State Court, but she doesn't have to. There's a federal remedy available for this very reason. When your rights are infringed under the federal Constitution, you get a 1983 claim. An assault and battery claim under New Mexico state law would be a completely different claim. She's under no obligation to pursue that remedy, especially if, and she should, she thinks she'll have a better chance at getting a result under a federal court than she would under a New Mexico state court, where the police officers who testify probably hundreds of times in their careers in front of the judge that they would be going before, and who serve the jury that they would be sitting with, would be potentially getting loads of bias. He also mentioned that there's a sovereign immunity statute in New Mexico specifically that would preclude lawsuits, presumably if they could raise a defense of sovereign immunity. There's the qualified immunity claim. This is, I think that she could bring an assault and battery claim doesn't make it reasonable at all that she should have. The idea is that they used excessive force. And if she can show excessive force, then she obviates the qualified immunity, right? Like, isn't that the idea?
Yeah. I mean, also, there's no reason she can't file except for the sovereign immunity. That was
right.
Nice.
Yeah.
No reason she can't file. Sovereign immunity, it's like we're a summary judgment averse state. Like, you're that summary judgment averse. If someone says sovereign immunity, they're going to let it proceed to trial for what? Right.
It's that was a strange exchange. I just wanted to noodle through that. That was
no.
Very
I have zero objection to you expressing your confusion because I'm having many of the same confusions.
I think Alito did lead him to a nice trap, which was the admission that there is no submission requirement to have a seizure. Because that's been the argument. And he just obliterated that. He said, look, if you grab someone's shirt for just a moment and then they get away, weren't they seized for the time you had their shirt? Yeah. He says, probably. So you don't need to submit to the authority to have a seizure. Correct. Well, there goes that element of the argument. Now he's in agreement with the petitioner on that portion. I think that was an important thing to happen. I mean, he's still going to argue that that there has to be some level of physical proximate control. He hasn't said proximate, but that's what he means. A proximate level of control that is part of the seizure, and that the bullet doesn't rise to that. But he's at least gotten rid of the submission argument. So weird.
Fourth Amendment, that all of our cases, including Hodari, recognized by Justice Scalia, who very much was a advocate of the common law and quite well informed about it generally, that has to do with the Fourth Amendment's protection of bodily integrity. It is why we call putting a needle in someone's arm a seizure that requires either probable cause or exigent circumstances, etc. And all of the common law cases that the other side has quoted to talk about not the seizure of the person in stopping their motion, but the seizure of the person with respect to the touching of that person, because even a touch stops you. It may be for a split second, but it impedes your movement and offends your integrity. You want us to add something more to the word seizure, you say, because common sense says that when a person is held for some imperceptible period of time, a few seconds, more than a few seconds, I don't know what your answer to Justice Alito meant, that is more of a seizure than putting a bullet in someone. Am I understanding your argument accurately?
I think, Justice Sotomayor, I disagree. I don't believe we are asking the court today to add anything, to add any extra layer of analysis to the seizure issue beyond what is already existent in this court's case law and in the common law.
Excuse me, counsel. No, you're asking us to reject the clear line drawn by Hodari and say that Justice Scalia was wrong about what the common law showed. That's exactly what you're asking us to do. You're saying it was pure dicta. His entire analytical approach was wrong.
She just called bullshit big time. It's like, that's what we were doing. I'm like, yeah, that's kind of what you're doing. Bullshit. You want us to say that Scalia got it wrong? It was all dicta. His entire analytical approach was wrong. So you're not asking to add anything to it. I'm like, okay, Justice Sotomayor just laid it down on the table.
And she did that very well. The other, can you scroll up just a bit? There was something she said that. Oh wait, no, never mind. It was just a point about Sotomayor in general. Sotomayor is far from an originalist. However, This case has another element to it than originalism, and that is that you have at least one Justice Sotomayor who is a justice-oriented justice,
Sure.
and has is a minority, one of the few minority justices on the Supreme Court, and in a minority community that would be particularly susceptible to certain violations of rights by various people. She's seen as an ally to illegal immigration for these types of reasons. So you've got a confluence of things happening here. You've got the originalism argument of Justice Scalia, and then you're rolling in lockstep with the justice argument that police force has to be very careful, because even if it's applied correctly in a particular case, it's very easy to apply incorrectly, and we don't want to allow that sort of thing. So you've got these cool merging of judicial lines here that I like. Sorry,
I agree. That's fine.
I don't know, Your Honor, that we're suggesting that Justice Scalia was incorrect in his discussion of a particular facet of common law, that working in the outer boundaries of the common law of arrest, that was this idea that a person could be arrested as a matter of constructive arrest by the mere touch.
Well, let's put it, the Fourth Amendment doesn't talk about arrest. It talks about seizure. Those are two very, well, a seizure is a form of arrest, whether you stay arrested or not, just as in your example of the person pulling away and running away. You can still be seized, you can still be arrested, and then run away.
Yes, I believe that is correct, Justice Sotomayor. Every custodial arrest, every traditional arrest is a seizure, but not every form of arrest would constitute a seizure. Absent that element of control, absent that element of the officer taking possession over the person, which was not a...
That's a strange argument, because arrest and seizure are kind of synonyms for each other.
Yeah, they both mean to halt or to stop.
They mean to stop.
So I don't know how you could say, well, not every seizure is an arrest, or not every arrest is a seizure. There are different meanings. An arrest tends to be the more involved process. See, that, which goes against his argument. Like, the seizure is the shorter version, I guess. Yeah. But an arrest started as a seizure 100% of the time. It almost had to. That's the idea, right? Like, right. I don't know how I guess I can see a seizure without an arrest. If a cop just says, "Hey, stop," and then, very briefly determines that there's no reason to keep you, you've been seized for the purposes of the Fourth Amendment, but you're not under arrest by that officer. But to get to be under arrest from an officer, you must have been seized necessarily. So that's his approach here is very weird. I don't know what's going on.
All right.
Without a feature of constructive arrest.
But that was not, that has that idea of control as opposed to intrusion, laying your hand on someone. That was all the common law talked about, wasn't it? You try to distinguish away those cases, but that's all they reference.
Respectfully, no, Your Honor. I would point to the English decision in Genner versus Sparks, for example, where the court made the distinction between the arrest by the touch, allowing the bailiff to break into the house to actually seize the debtor who is in the house. I would also certainly point to contemporary dictionary definitions existing at the time. For example, Johnson's Dictionary of the English Language that said to seize is to take possession of or to grasp.
Grasp. So that would be, grasp. Counsel, thank you. My time is up.
Thank you, Your Honor.
A grasp is a touch. I mean, that's what she was getting at there.
Yeah, exactly, yeah.
Justice Kagan.
Mr. Sandridge, when Hodari D. said, and I'm quoting now, an arrest is effected by the slightest application of physical force despite the arrestee's escape. That's what you're saying is dicta?
Yes, Your Honor.
And when Hodari D said, I'm going to try your patience a little bit, I'm sorry. When Hodari D said, to constitute an arrest, however, the quintessential seizure of the person under our Fourth Amendment jurisprudence, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. That's dicta?
That is, again, because it was divorced from the actual facts of the Hodari case.
So yes, and when Hodari D says the word seizure readily bears the meaning of a laying on of hands or application of physical force to restrain movement, even when it's ultimately unsuccessful, that would be dicta?
I believe it would.
Just a yes or no?
Yes, Your Honor.
Yeah, and when I'll stop, but it's not because I couldn't go on. Hodari D says this, I count 6 times, either in its own language or quoting somebody else. And that's kind of amazing, but it's only a 7-page opinion. So this is just like all over the opinion. It's the way that Justice Scalia reached his conclusion as to that case. So how could it be that that is not binding on us?
Because, Your Honor, it stands in contrast to the ultimate holding of Hodari D, where Justice Scalia noted that in order to seize a person, or in order to effectuate a seizure from the time of the founding to the present, the object of the seizure must be taken possession of.
I guess I'm sorry, Mr. Standridge, I didn't mean to interrupt.
No, that's fine, Your Honor.
I guess what strikes me is that you're using an impoverished understanding of what precedent is as opposed to what dicta is. I mean, these are not what we sometimes call stray statements, things that we said without thinking about them, things that we said without sort of realizing the consequences. These statements have a kind of self-consciousness and a kind of clarity that one, seldom sees in a judicial opinion. And it's clearly the way Justice Scalia thought he was coming to this conclusion. And the conclusion, you're right, it's not a force case. But essentially he's saying, well, look, you either need force or you need submission. And he's going through the common law to suggest why those requirements were not met. So I guess I'll just ask you again, I mean, if anything other than an ultimate holding is not dicta, this is not dicta, isn't it?
If anything other than an ultimate...
if dicta extends to anything beyond unless dicta is everything except the ultimate holding, this is not dicta.
No, I disagree, Your Honor. I think that in any discussion that is moored in the facts of the case, that leads to the ultimate holding would not be dicta. And that was the discussion in Hodari D, that attempted seizures are beyond the scope of the Fourth Amendment and that seizures require the taking of possession. And in fact, in looking at Hodari D, I noted that Justice Scalia cited to the case of the Josefa Segunda in 1825, where a revenue inspector had attempted to seize a ship. And this court said he hadn't done so in part because he did not use force sufficient to compel the submission of the crew and captain of that ship.
Thank you, Mr. Standridge.
Justice Gorsuch?
Thank you. Counsel, your colleagues on the other side suggest that your rule will lead to tricky line drawing problems. What do you say to that?
I respectfully disagree, Your Honor, as you might imagine. Our rule has a definite and logical endpoint. An officer in the field will know whether or not he or she has seized a suspect because they'll know whether that person has been brought under their possession, custody, or control. Now, an officer in the field may then contemplate that if they use some level of force and the person that is the subject of that force is not brought under their control or is not stopped, A reasonable officer under County of Sacramento versus Lewis could then also assume that the fleeing person may come back with a 14th Amendment claim for violation of the substantive due process clause. But in terms of asking police officers working in the field to understand whether or not they have seized a person for the purposes of the Fourth Amendment, this is the easily administrable rule that this court tends to look for.
Okay, and as I think you just noted, and I just want to make sure I understand, you agree, not only would there be a battery claim under state law, there could potentially be a 14th Amendment excessive force kind of claim as well.
That is precisely correct, Your Honor. It becomes something of a...
How does that work? The 14th Amendment usually comes about because it's incorporating some other provision in the Constitution. So how is it that you have a 14th Amendment excessive force argument if you don't have an underlying Fourth Amendment claim to a seizure? Where is this 14th Amendment claim to excessive force being rooted in, if not the Fourth Amendment seizure clause? How does this make sense?
I guess what they said before, that it was a substantive due process claim, but excessive force doesn't come from due process. Excessive force is the reasonableness of the seizure in the first place, I think.
Yeah, but substantive due process in the 14th Amendment context is been the mechanism by which incorporation has been done, has it not?
I suppose so.
Because it's not procedural due process. It's not the privileges or immunities clause. It's substantive due process is how the 14th Amendment has incorporated stuff.
So it'd merely be applying Fourth Amendment to
right. So you'd be saying the substantive right is the Fourth Amendment right. So you can't have it without the underlying right.
Yeah.
I don't understand how that makes sense.
I don't either. His whole argument doesn't make sense to me, because he's talking about how it's easy. His proposed solution would make it easier for officers in the field when they know that they've given a sufficient level of force. But that's a question of, I mean, that's a hard question to answer in the field. Like, if the question is whether you've used any force versus no force, that's easy to answer. Sufficient level of force is not easy to answer. There are variables with it. Totality of the circumstances approach that would have to be resolved by a court. His proposition is terrible for the field, in my opinion.
Chart. A given plaintiff who believes that they have been the subject of physically abusive governmental conduct or excessive police force, and plead their facts in their complaint.
But plead their facts rooted in what legal claim? This is the exact problem you and I were having yesterday on the stream, Nick.
Yeah.
It's like you can have all the facts in the world, but if they're not rooted in a legal claim, who cares? So yeah, they can plead the facts, but rooted in what legal theory? Jesus.
Then they claim in count one that this constituted a seizure, it constituted an unreasonable seizure, and that's violated my Fourth Amendment rights. In the alternative, if this was not a seizure, it is still physically abusive governmental conduct that shocks the conscience of the court.
So that's due process.
Shocks the conscience of the court. So we're gonna say that this is so bad that we're gonna justify a constitutional violation out of nowhere. Fun. Let's ignore the Fourth Amendment, but we'll create something on the fly because it shocks our conscience so deep.
Thus, the defendants are liable under the 14th Amendment, to say nothing of pendant state law battery claims or assault claims. It's a bit of a trade-off. In the Fourth Amendment context, the plaintiff has to overcome that initial hurdle, that threshold issue of showing the seizure. Whereas under the 14th Amendment, they would not, but then they still have to show that the conduct falls within the culpability spectrum identified by this court in Sacramento versus Lewis.
Is it your view that the common law of arrest is wholly irrelevant when we're interpreting the term seizure under the Fourth Amendment, or does it have some role to play?
It absolutely does have a role to play, Your Honor. We look at the common law of arrest as it existed at the time to see if it gives us a clear picture as to what the common sense, common understanding of the term seizure was. Where it does not, then this court looks inward. It looks to how it has traditionally analyzed these terms or defined these terms in light of contemporary norms.
Okay. In terms of Hodari D, would anything be different about the court's holding there if the passage about arrests were excised?
No, Your Honor, I don't believe it would, because the holding that is moored to the facts of that case would still stand.
Why is that?
Because the idea that, looking at it from an objective standpoint, whether Mr. Hodari, Hodari D was seized at the time he threw the drugs away, which was the narrow issue there, just the analysis of those facts in light of this court's existing precedent compels the result that the court actually reached. He was not seized.
Okay. Is there any, the number of lower courts, of course, held that this passage was dicta. Is there anything disrespectful about saying that some portions of a judicial opinion are essential to its holdings and others may not have been fully considered, especially when there's been no adversarial testing as there wasn't in Hodari?
I don't believe so. I don't believe it's a matter of disrespect. I simply would posit that it is a matter of careful judicial analysis.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Mr. Standridge. With respect to Hodari, I think there are two issues. First, was Justice Scalia right in the discussion? And then second is the precedent question. On the first question of whether he was right, you're arguing, as I understand it, that Justice Scalia and really all 9 justices in that case were wrong about the original meaning of the Fourth Amendment.
Oh, it's unanimous.
I'd like you to explain where you think they made the mistake.
I wouldn't say that the common law discussion in Hodari D was incorrect. It certainly stated a rule of arrest that existed in the Dickensian era. Where I think the difference is, as applicable to this case, is that it was not a complete picture of the common law of arrest as it existed at the time of the ratification of the Fourth Amendment. The ordinary meaning, even then, even 200 years ago, was that an arrest, a typical arrest, resulted in the person being in custody or being taken possession of by the arresting officer. What again, I think that the Hodari court, and I believe this was recognized later in Sacramento versus Lewis, is that that particular discussion would simply explain what the Hodari case was not.
Well, I guess I'm a little confused. In your view, is a mere touch, but a touch with intent to restrain, is that a seizure or not?
It is not, because it is missing the element of control.
Okay. Even though the common law cases did, as cited by Justice Scalia, said that mere touching with intent to restrain was, I think you are saying it's wrong.
What I'm saying is that as a broad proposition, it is wrong. The cases cited by the court in Hodari and cited and relied on by the petitioner here were again limited to that civil debtor context that is not corollary or is not compatible with the modern conditions of police work as we know them today.
Whew.
In terms of the Hodari D as a precedent, picking up, I think, on what Justice Kagan said, I read the case to say there are 2 ways you could have been seized. One, by force with intent to restrain, or one, by a show of authority, but in the show of authority, you need actual submission. Those are the 2 avenues that the opinion outlined as I read it, and neither was met in that case, leading, as Justice Thomas said, to the bottom line holding that there was no seizure there. Is that an incorrect reading?
No, Your Honor, I believe you have the reading of Hodari exactly correct.
Then he's wrong. Then he just killed his own argument again, because he said there were 2 avenues: force with intent to force with intent to seize or whatever, and then, or the other avenue, which is a show of authority with submission. So here, the bullet, there's no argument that a bullet fired from a police officer is force. And if they fired at the car in an attempt to stop her, that's force with an intent to seize. And I don't know why else what other element they would be admitting to. I guess we weren't trying to stop her. We were just trying to kill her. Or we were trying to scare her off and it happened to strike her. Those would be worse admissions. So again, this guy is floundering in his argument here. Kavanaugh is actually kind of turning him around. I hate Kavanaugh's speaking style, but I think it's really disarming at the same time. So
yeah, that's right. Yeah, we get what do we got? 5 more minutes of this. Yeah, 6 more minutes. Okay, let's wrap this up.
Yep.
The other side makes a point, and I think Justice Breyer was getting at this. There's some symmetry with Jones, the GPS case of placing a GPS on your car, intent to search, touching your body with intent to restrain. Can you respond to that symmetrical argument that the other side makes, and whether there would be any, I guess, lack of symmetry with Jones if we were to rule in your favor here?
Yes, Your Honor. Because Jones was a search case, it was brought under the search clause. There is an asymmetry given the different interests protected respectively by the seizure clause and the search clause. Again, the search clause is more broad. It doesn't only affect the stoppage of a person's movement or the restraint of their liberty. The search clause is aimed at any action that invades the person's interest in privacy. And so that is where the asymmetry comes from, and that is why Jones is not analogous.
He missed it on Jones.
Okay,
yeah, we did.
Thank you.
Mr. Standridge, a minute to wrap up.
Thank you, Mr. Chief Justice. I will end today where I began. From the time of the founding to the present, a Fourth Amendment seizure has required possession, custody, or control. That was a matter of common sense and common understanding in 1791. It was a matter of common sense and common understanding throughout the 18th and 19th centuries and 20th century and on through today. At no time was Roxanne Torres ever under the custody, control, or possession of either Janice Madrid or Richard Williamson. And because she cannot meet that hurdle, she cannot meet that threshold question of showing that she was seized, she cannot bring a claim under the Fourth Amendment for violation of the right against unreasonable seizures. And it is for those reasons, Your Honors, that we request that the 10th Circuit's decision be affirmed in all respects.
Thank you, counsel. Ms. Corcoran, 3 minutes for rebuttal.
Real brief pause.
Yep.
Before the rebuttal. The reason he missed it on US v. Jones is that could have been the question in US v. Jones, but it's not the area Scalia went to, and it shows a fundamental misunderstanding of how this guy is viewing an originalist approach to search and seizures versus how Scalia approached searches and seizures. While, yes, the search clause does protect a privacy interest, Justice Scalia acknowledged that the search clause also explicitly protects a personal property right in your in the security of your property in and of itself. And so the very act of placing a GPS location tracker on the bottom of a car, irrespective of anything else, was itself a trespass upon the rights of property in that car that Jones held. And therefore, that was enough to violate the search clause. That is analogous to how seizure law is applied, because seizures, he keeps saying it applies to the arrest or the stopping of a person, but seizure also applies to the confiscation of items. It is the implication of your property right in your property as well as your person. And he makes this distinction between the two, saying that there's different there's an asymmetry or different standard applied to searches versus seizures. But I'm not familiar with any case law that delineates between the two as protecting separate interests. That the Fourth Amendment is somehow split between them and the rights go into one bucket or the other. That's a ludicrous argument.
No, it really doesn't make sense. And it makes less and less sense the more he explains it, because he tries to draw these delineations and he winds up with these wild results. He's like, well, the police of today are so modern, it doesn't apply. And let me also contradict my argument 8 other ways. So it's like, I'm like, this just cannot even be bothered. So yeah, we'll have 3 minutes worth of wrap up to conclude this thing before we try to predict how many votes to reverse, because yeah.
Oh God.
Thank you, Your Honor. To start first with Justice Gorsuch's question about the framers' textual choice, it made sense for the framers to use the word seizure because the word arrest covers only seizures of persons, and they needed language that would also encompass seizures of property.
Good job.
Their use of the word seizure to cover arrests was consistent with the founding era dictionaries and case law, which treated arrests and seizures of persons synonymously. As Ms. Tableson said, we see that in Entick v. Carrington, where the court repeatedly refers to the arrest of the plaintiff as a seizure, as did the underlying warrant at issue, and that was a criminal arrest. Second, Mr. Standridge cited Payton as supporting his position, but there the court found that the common law was unsettled about the legality of a warrantless home invasion to make a felony arrest. In contrast, respondents have not cited a single founding era case where the court found that no arrest or no seizure occurred because the suspect escaped after the officer touched him. This is not an area where there's any doubt about the common law. And with respect to the lack of cases involving inanimate objects, as I said earlier, this court recognized in Castleman that the application of, or that the common law of force included its indirect application, and that's consistent with Brower. In drafting the Fourth Amendment, the framers chose a term, seizure of person, that was widely understood at the time to include any touch intended to restrain, even when unsuccessful. That common law reflected the founding generation's belief that the infliction of physical force on the body is itself a profound intrusion on personal liberty, regardless of whether it results in physical control. That is the concept that the founders gave constitutional significance in the Fourth Amendment. And to the extent we think about seizures differently today, it is the ordinary meaning at the founding that matters for the purposes of interpreting constitutional text. Contemporary shifts in language do not diminish our constitutional rights. The alternative offered by respondents is a regime that, as a practical matter, provides no constitutional protection from excessive force by the government so long as the victim can escape afterwards. A constitution that's unconcerned with the police shooting someone without any provocation so long as the person doesn't immediately stop moving. It's not just counterintuitive, it defies the sanctity of the person that forms the foundation of the Bill of Rights, the right to be secure in our bodies from unreasonable government intrusion. The court should reaffirm what it unanimously concluded in Hadari D. 30 years ago. At the founding, the Fourth Amendment prohibited the government from attempting to restrain private citizens with unreasonable physical force, regardless of submission, and it continues to provide that protection today. Thank you.
Thank you, counsel. The case is submitted.
Sweet.
We will hear argument first.
We don't need to hear it all over again now.
That
was very good. Very good closing. Very well done. Very nice wrap up. I like it. I like it quite a lot.
Yeah, that was very well articulated. Nailed the points that that we've been bringing up with the problems with the other guy's argument. Hit home the fact that, look, if we were to follow this, police officers could literally just shoot people, and that would be
and also enter their homes as long as they're not looking.
Right. Nonsensical outcomes. That was a very good closing statement. Very good closing statement.
So I can only hope at this point that it's reversed, and I don't know if it'll be unanimous, but I'm kind of hoping. But yeah, 7-2 or better to reverse would be what I'm hoping for.
That's exactly what I was thinking. I hope it's 9-0. I could maybe see based on the questioning, but you can't ever trust the questioning.
Yeah.
A lot of times justices will ask questions just to force you to say something. But if there's two, I say maybe Breyer and Alito, which would be a weird alliance.
Weird combo.
But I almost think it has to be a 9-0. It seems extremely clear cut, but Breyer and Alito had some weird questions. The fact that Breyer didn't have any questions for the petitioner was very strange to me as well. You went gray.
My camera has completely gone out. I know, it's very sad for me. It is extremely, unbelievably all the sad. Well, it was nice while it lasted, I guess. Let me start off OBS again, since I was using the virtual camera. That's probably has something to do with it. There we go. Yay. Yeah. So so this is something I've done a lot before. The Supreme Court reacts, and I think what Nick said at the top, it's usually oral argument at its best. It's usually legal arguments at the most interesting. And even where Nick and I are like, this answer seems pretty easy. Like, we all kind of learned something. Apparently, the Fourth Amendment doesn't apply to modern police forces and other things.
Learned about Dickensian debt collectors.
I learned about the Dickensian debt collectors. I know you have to go at 8, so we'll wrap this up. I just want to say thanks to my guest Nick Rekieta for his participation in this chat. I've certainly enjoyed streaming with him. I have to say, I do, to be honest, enjoy streaming with him a little bit more in the middle of the day and a little less so at the 11 p.m. hours, where he's like, let me start at 11 p.m. and do a 3-hour stream, and then let me go watch movies on Amazon till 6 in the morning. I don't know what's up with that plan, but okay, it seems to be working for you.
I apologize profusely for my late nights. They're detrimental in many ways, but I have so many people who tell me, please, please, please keep the late night stuff. I work overnight, I drive truck or whatever, and it's just nice to have something that I want to listen to. So I'm bound. I'm oath and honor bound to late night streaming, no matter what else happens.
Well, I'm pleased that we were able to have you make an appearance on my stream, so that was nice.
Well, this was a lot of fun.
We got to do something that I'm used to doing. So hopefully you enjoyed this kind of thing. Because this is like, this is what I do. We listen to the Supreme Court and we dissect it and we ask what the hell's going on a lot.
It's a blast because, again, even though I think the one guy, made terrible arguments, the reason he was making terrible arguments is because he had a terrible factual scenario and a horrific uphill battle on what he had to do. The only saving grace being that for some reason the 10th Circuit had affirmed this bad outcome. Yeah. So, but
smack it down hard, man.
He's working with what he's got. Definitely this should go the way of the petitioner. It should. I don't know if it will, but it should. It should.
No, I hope I am not surprised again, like I was on Kansas v. Glover, where I was surprised, and this is not another blow in the Fourth Amendment arena. Because the police can just stop me because they think I stole a car without more. It was problematic. The police can shoot at me, and as long as I can get away,
and importantly, shoot at me not after I've done anything. Like the person, they have no indication that this person was even, because it would obviate the question if they had turned on their lights, because that person would have then been seized for the purposes of the Fourth Amendment at the time of the flashers or whatever. It's that they were. Right. Yeah,
and I also assume that quite a lot of the volume I'm getting is from Nick's channel. But for those of you who are actually from my channel, I just wanted to make sure to give Nick a shout out, and I'll go in and amend the video description to put his link in the description below. But if you haven't checked out his stuff, he has a acerbic, aggressive argumentation style, which although he seems to analytically agree with me, he expresses it with a bit more panache and flair
anger
that I might on another occasion. So I've really been enjoying it. And check out Nick Rekieta's channel. He normally streams at 11 when all of us are sleeping. And I'm going to sign off so that my guests can go. Cheers all. It's been a pleasure. Later. Bye.
Later.